Good evening. Welcome to the Warrant Committee. It's February 12th, 2025. Karen, could you call the roll, please?
Sure. We have Tom Caldwell. On Zoom is Steve Ryans. Lori Connolly is here. Elizabeth Dillon, Jay Fundling, Allison Gagnon, and Julie Joyce are on Zoom. Andrew Coe is here. Macy Lee is on Zoom. Peter Mon is here. Julia Maxwell on Zoom. Brian McGuire is here. And on Zoom, we have Aman Nagasi, Ron Sia, and Judy Steele. The quorum.
Thank you very much. Welcome, everybody, to the Warrant Committee. Tonight, we're going to be discussing some of our remaining articles that include our lighting bylaws, our bylaws submitted by the Planning Board concerning ADU and the site plan approval, and also a discussion on the citizens' petitions that were submitted. We have Peter Mello, our town council, here to discuss these matters with us and to answer any questions we may have. I know that there were several questions that we had, at least concerning, concerning each of the articles I mentioned that are still outstanding. So, Attorney Mello, if you want to come up to the table, welcome. Thank you. Thank you, Attorney Mello, for coming. We appreciate it. I know you are a very wanted man throughout the town. so we appreciate you making time for us this evening. So I know we spoke very briefly before. So we have obviously a series of these articles that we're going to be making some comments on for the town. And based upon, the planning, lighting, and the citizens' petitions, if you want to just maybe from your perspective as town council, just break those down for us. And I know we do have some questions that I forwarded to you that I'm sure that you'll address during your presentation.
Sure.
If you want to call it that. But,
yeah.
So the floor is yours. You can commence with any of the articles I mentioned.
Okay.
You think is appropriate.
Yeah.
The floor is yours.
Yeah. No. Happy to. And I want to mention that I received some emails in recent days with different questions and materials associated with different questions and articles. I had unfortunately a death in the family and had been tied up over the past couple of days, and so haven't had a chance yet to really drill down into to a granular level on a lot of what was provided, but have reviewed it generally. So happy to talk about it. If there's any need for any follow up, I'm happy to provide it in the coming days. But generally speaking, and it's probably cleaner to just field questions than give an overview of all the articles. But with respect to the zoning articles, I did send both the site plan bylaw and the ADU bylaw to the municipal law unit for review. Got some comments back on the former, still awaiting comments on the latter. So I haven't received any response with respect to the draft ADU bylaw. Look forward to those. Expect those pretty imminently, but I did flag the schedule. So I mentioned that the planning board's meeting tomorrow night. So I'm hopeful that we can get comments back tomorrow. But as soon as we get them, I'll circulate them. So
if you just to interrupt you, so just so it's clear, the site plan review has been.
Yes. In
terms of the Attorney General's office,
right.
It has been approved as written.
We had a discussion about my discussion with the MLU informed my comments. So I wouldn't say it's an informal review process. I wouldn't say it's been approved, but that was something I wanted to do to I like to do that whenever I can. Because they're very helpful and responsive over there, and so.
Sure. Now, as to the ADU,
yep.
I think you have some information on that.
Yeah. So as I mentioned,
ask a clarifying question, or would you just
sure,
say?
Jay.
Okay, I'm trying to understand. The version we saw, is that post review and comments from?
The version that
sorry, of the site plan review law, we saw a version. Is that after you got it reviewed and you made comments on it?
I'd have to confirm that, Jay. I'm not sure because it's been because of the timing of everything. I'd have to confirm that. I don't want to say definitively. I think so. And I didn't have, I don't think I had major changes to the version I saw, but I'd have to confirm. So.
And as to the ADU, is there any new information from HLC?
I just heard that, I wasn't aware of this. I just heard within the past few minutes that the draft or model bylaw has been issued. I haven't seen it yet. So they do have a model ADU bylaw. Apparently it's out. So I'll be interested to take a look at that. I haven't seen it yet. And I'd imagine that whatever forthcoming comments we get back from MLU will reflect terms of the model.
So is it, I guess, Mr. Mello, Attorney Mello, it's fair to say that there could be additional changes made based upon, I guess, the review by the municipal law unit or the suggestions they make, but I think more importantly, as to the ADU, there could be some other things in there that we haven't addressed. Is that accurate?
Yeah, fair to say. I mean, it's hard to predict. It's all so new, and we had what were sort of the tools we had to get a sense of what was within the legal boundaries. They had some draft regulations; those were changed. Ultimately, we have this model bylaw. This is all kind of hot off the presses, so it's possible that that there could be some changes. But I guess, maybe I don't want to forecast it, but I'd be, based upon what I reviewed, I compared the proposed language with the regs, and I'd be surprised if there was anything materially different, or any comments that required any substantial changes. But it's hard to, I guess, speak about it in the abstract. It's probably premature to say definitively. We'll see what the MLU comes back with, but yeah, I guess it's fair to say there could be some tweaks.
Okay. And is there anyone you spoke to there?
MLU?
Yes.
Beyond submitting it and receiving confirmation that they're reviewing it, I haven't. There's been no detailed discussion about the terms and what they might be looking at in terms of changes. It's been very preliminary, and yeah, we got it. They invited municipalities to submit draft language, so I basically we availed ourselves of that invitation, and but haven't had a conversation about the details of the language yet.
Mm-hmm. You may have, I think you and I may have discussed this. So we did a pretty pretty detailed overview of the two bylaws submitted by the planning board, the EDU and the site plan. We kind of went through it line by line. I know I'd mentioned we had made some changes, some Scrivener changes that we made. Obviously asked the planning board, line by line, section by section, what does this mean? What does this do? I know they indicated a lot of this language in both were modeled after similar articles or bylaws in other communities. So I think my question is to you, we could be seeing that bylaw again at some point in the next week, maybe?
The site plan?
The site plan and
the ADU?
Yeah. Is that?
Yeah, I mean, I'm not sure where I guess I'm not the one to speak to that. I don't know where it sits with the planning board at the moment. I think that it's still, my understanding last I heard, I've been, as I said, a little out of pocket the past couple of days. I know they had a meeting on Monday. I don't know. I don't know what happened or what was discussed exactly where things stand, but.
Okay. Well, you know what I'll do right now, just in terms of the site plan review, I know that some members of the committee had some questions as to that, so I'd like to open it up. Brian?
Yeah, I have a question. So if on their ADUs, there are restrictions that the planning board has on ADUs. If the town approves it, and then the state comes back and says like one thing in it is not valid, or you can't do one thing, what happens?
Typically, what the MLU does is they'll identify the offending language and just disapprove with respect to that. They'll be able to isolate the language that they disapprove of and say, we disapprove of this sentence or this term or this provision. Often what they'll do is they'll flag a potential concern, but they'll approve it subject to the caution that the town consult with council in terms of, applying it. We recommend, I'm paraphrasing, but we recommend the town consult with town council regarding the application of this requirement to make sure that to ensure that it's consistent with, whatever law they're concerned about.
So the rest of it,
Yeah, usually they'll
Stay.
say, right, they won't wholesale invalidate an entire provision. I mean, I guess perhaps in some circumstances they could, but typically they don't do that. They'll just I isolate the offending provision, and they'll say, we disapprove of this language. We approve of the bylaw subject to our disapproval of section 3.7 subsection A.
and that would be the only one that they would cross out.
Exactly, yeah. The rest of it would be approved, right?
Okay, gotcha.
Yeah.
That's helpful.
You all set?
Yep.
Okay, Judy.
Thank you. So we discussed the ADU in detail the other night, and a question that had come up, if you have seen the draft, what is permissible to write in the bylaw about terms of length for a lease if the ADU is meant to be a rental unit?
Yeah, no, that's a great question. That's a question that's probably the provision that jumps to mind most prominently of what caught my eye when I looked at it. Municipalities can regulate reasonably. The question would be, I think, is that a reasonable regulation? And that's one thing I'm interested in and sort of anticipate the municipal law unit addressing in its forthcoming comments. I have the same question. I mean, I don't know that I can forecast it. Is that reasonable? I anticipate that will be addressed. So, but at the moment, I don't know. It's a good question.
So a little follow-up if I could.
Sure.
So according to what you just said, municipalities can regulate terms of lease in an ordinary circumstance, not just ADU?
No, I think that what I'm saying is that any regulation of ADUs, has to be reasonable. I think that the question that'll be posed, and again, this is all brand new, so I'm just anticipating, but I think the question would be, is that a reasonable requirement with respect to ADUs? Is it a reasonable regulation? And I guess I'm interested in what the AG's office or the MLU, which is an office within the Attorney General's office, has to say about that. I do think that I expect that they'll address that question when they provide comments. And if they don't, then I guess that would suggest that it's not problematic, but we'll see.
Mr. Chair, may I ask it?
Of course, Judy.
Thank you. We also discussed site review for the ADUs. And as I understand it, and I'm open to correction here, if you have a single family house it doesn't trigger site review necessarily. But on a multi-unit project, it does trigger the site review requirement. So would you interpret, if you take a single family house and you're going to add an ADU, I see that as multi-unit. You have the primary unit that's most likely more than 900 square feet, and now you're adding another unit which can be no larger than 900 square feet. So that says to me you have a multi-unit now, and it would trigger the site review. Do you interpret it the same way?
Well, I think one of the questions that first arose in my mind, I think there was language in the site plan review bylaw that required site plan review for ADUs, and at the time, I think there was language in the draft regulations, the draft ADU regulations, which effectively said that you can't impose any more stringent requirements upon ADUs than single-family dwellings. I think that language was removed. So, is the question of whether site plan review can be required of for ADUs. I think so. I think that's permissible. I think that I was first concerned about that proposition when I saw the draft regs, but I think they modified the draft regs to remove that language. So, and I have to go back to my notes. I don't have a clear memory at the moment of whether the municipal law unit flagged that, but I think that probably is okay. But I guess I'd have to go back to confirm whether we discussed that or what the final verdict was on that from the MLU.
Okay, thank you very much.
Sure.
Ron?
Appreciate it.
My pleasure.
I said a procedural question, but I guess first, sorry to hear about the loss.
Oh, thank you. Yeah,
hope
appreciate that.
Everyone's okay.
Thank you.
I guess if the law needs to be changed, I was just wondering procedurally, would it be for the planning board to make the changes with you, or would it be for us to propose changes based on the state's input?
If the terms of the bylaw need to, well, it's the warrants.
So, yeah.
Right. So I think that, if there were changes, then they would need to come on town meeting floor, right? And, so was that what you were asking?
Yeah, who would be responsible for drafting those changes? Would it be for us as the warrant committee to propose changes, or would it go back to the planning board and would they resubmit an updated version for the warrant?
Right. Well, no, the warrant's out. Right. So I think that, I think planning board would, the planning board's going to provide a report, right? And so they might, address any changes in a report. And I think the warrant committee, as it's customarily done, where you would propose changes to language, could express that in your recommendations, right?
The green sheet, I guess.
Right. But ultimately, any change to the language would need to come through an amendment at town meeting.
Okay.
The warrant, because the warrant's issued,
Right.
it's, it need to be amended from town meeting floor.
Attorney Mello, I have a question. I think that this might be a big question that members of the committee have, but maybe just the general public. And you touched on it, but if any provision in the ADU, let's use that as an example, if the AG said, we don't like this whole thing, I just want to make it clear, we don't like this section, you indicated that would be obviously extrapolated, corrected, removed, amended, but it wouldn't totally invalidate the whole bylaw, correct? And I think
Typically, that's not what they
Okay.
do. Typically, they'll either disapprove of language or they'll flag that you have to be careful about applying it. But they won't, and I'm not sure that, I'm not saying that there wouldn't be any circumstance where they wouldn't say this whole thing is, invalid. I don't recall ever having seen that. Usually they isolate whatever, whether it's a sentence or a section or a term or some requirement. Like a bylaw seeks to impose fines that exceed the statutory maximum. We disapprove of this, this requirement, type of thing. But they won't invalidate the whole thing. No.
And
Yeah.
yeah, and I think that's, just from information I've received, I think people are just concerned that if the AG says no good, we have an ADU by right and the town can't regulate it. So I think some people just had some concerns about that. And,
Yeah, for example, taking the 12-month threshold as an example, I think if that were included and the AG or the MLU thought that was unreasonable, I think what it would say is, we disapprove of that requirement because that exceeds the scope of a permissible, reasonable requirement for ADUs. And the rest of the language would remain intact, and then that requirement would be invalidated or disapproved. Again, or they might say, we caution that we recommend the town consult with counsel before applying that requirement to make sure it's consistent with the law, type of thing.
sure. Brian.
If they thought on that, thinking on that frame of thought, if they thought 3 months was the right answer, would they just say, you think they should change 12 months to 3 months, and that would be, would they do that, or would everybody have to go through the whole process again?
Yeah, they don't typically, they wouldn't unilaterally impose a change and say, we're going to reduce this. We approve 3 months, we're going to reduce it from 12 to 3.
They wouldn't do that.
No, I don't think so. They might say, we disapprove of this language, and they might cite to other decisions and say, we've, in other cases, we've approved up to X months, and might cite a decision or two. They might offer that. A lot of times, and this is true, if, the MLU has this helpful repository of its decisions, it's keyword searchable. So, a lot of like site plan bylaw decisions have been generated in the past couple of years. So you can get a flavor for what they've said about different provisions from decisions they've issued in those matters. And they oftentimes tend to use kind of stock repetitive pasted excerpts like they'll cite the same cases for the same propositions and kind of repeat the same mantras in different decisions. So you can, over time, get a sense of what they're going to say based on reviewing how they've decided other similar bylaw language. So I think that in a year or so, we might have a better sense of what timeframes have passed muster. But at the moment, I doubt that this is all brand new, so we wouldn't really have that.
Lori.
I was just going
No,
to
I'm
say,
sorry.
Jay gave us a copy of a response from the municipal law unit that just excluded a certain sentence
Mm-hmm.
from an article that was submitted to the state. Did you remember?
I don't.
It was on the outdoor lighting bylaw from New
Yep.
Marlboro
Okay, I don't remember them striking a sentence, but there's been a lot in my brain the past week.
about the fine.
Okay.
We disapprove, except for the certain text in this article
Yep.
authorizing a fine that we disapprove because blah, blah, blah.
Yep.
Other comments, see below. So they identified the specific,
Yep.
as you said.
Yep.
Anyone have any questions, like maybe about the short-term rental?
Because you're looking at me. Fine, I will ask the
That
question.
was for another reason.
Oh, just look at me for any reason you want. Okay.
Liz, you have the floor.
Thank you. I'm sorry about the loss of your family
thank you.
member as well.
Appreciate that.
So one of the things that we had talked about before, so I'm curious about your thoughts. So not any kind of a municipal attorney, so I don't know. but we had talked about the regulations. So I have it in front of me, so I'm going to cite to it. But in section 71.02 of 760 CMR 71, so 71.02, it's the definition of ADU. And it says that it's subject to, so little letter C, is subject to such additional regulations as may be imposed by a municipality, including but not limited to short-term rental as defined by, and then it cites to Mass General Laws, Chapter 64G, Section 1, which then in turn defines under occupancy. So it defines short-term rental as a period of not more than 31 consecutive calendar days. So we were talking amongst ourselves, does that, and again, I don't know, does that then mean that we would not be able to limit a lease provision for more than, and I think what they're trying to get at, I don't know, but I think what they're trying to get at is like an Airbnb, VRBO. I thought it was VRBO situation. But does that mean that we're limited to that 31 days? Or is it more like, you know, they're going to, like you said, they're going to look at what's reasonable under the situation. Could be 3 months, could be a year, you know. I was confused about that interplay between the not really that confused, but the regulation, the statute, and then our bylaw. And I'd be interested to see the model bylaw to see if it has anything, but I know it just came out.
Yeah, and I haven't
on
seen
Google
it.
anyway.
No, it's a good question. I think the way I read that, I could be mistaken, but I read that to mean we're not trying to infringe upon municipalities' rights to regulate short-term rentals. This isn't intended to encroach upon whatever power you have to regulate short-term rentals. I guess is how I viewed that.
So again, like the Airbnb, VRBO, we would be able to restrict that.
You retain the same rights you've always had as a municipality to regulate those. You know, whatever state law authority you have to regulate, the municipality has to regulate short-term rentals isn't in any respect reduced or inhibited by, you know, these new requirements is how I guess I interpreted that language.
Anyone else? So Attorney Mello, so I just want to clarify. So the law for ADUs is in effect right now,
Right.
as we
Yep.
speak.
Yes.
And the state now releases model language for this ADU guideline. Right. So I'm just saying it's frustrating, you know, that we're at this point. And I know every town and municipality is different in terms of how they work their zoning. You know, we're a little town. We have to go through the town meeting process and committees and stuff. So I just want to just clarify that from this member's position, it's a little frustrating to try to, you know, work it and then work it through. Do you have is there any information you have about why they delayed so long on this, or any idea? Or is it just how the state is working this through? And that's fine if it is, but I'm kind of perplexed on why they waited, you know, why this wasn't out January 2nd or something.
Right. Yeah.
You might not have an answer. It's more of a comment, you know, that would have been helpful to have this a couple of months ago.
Yeah. Yeah. I'm not sure what the. I can't really speak to the process of the timing of it. So.
And I understand that. Okay. Now, does any member of the committee have any questions about the site plan or the ADU? Any language? This is our chance. Jay.
I just want to clarify something that I brought up earlier.
Sure, please.
You might have gotten a message from, well, I got a message from Meredith Hall, chair of the planning board, and she confirmed that the version we saw was after the comments from town council. So I raised that question earlier. I got an answer. Want to tell the committee.
Okay. Thank you. Thank you. Thank you, Meredith, if you're watching.
I'm sure she is. The whole planning board is probably watching right now.
Whole town's
I-
probably watching.
Yeah, hi, planning board. Okay, committee, are we good with Attorney Mello, and any other questions concerning these two articles brought forth by the planning board? I know we had some lengthy discussions on them.
I just want to clarify that I heard something correctly, which is that you're aware of how the state defines short-term rentals, and that you also believe that the AG's office is not generally trying to interfere with town rights to regulate short-term rentals.
That's how I interpret it. Again,
So that
that's my,
so it's possible that more than 31 days, towns may be able to define short-term rentals something greater than what the state defines it as, in this particular case regarding ADUs.
I don't want to reverse that. I think, I was just saying that I think the way they've composed the definition suggests to me anyway that they were trying to clarify that any restrictions or requirements applicable to ADUs has to be reasonable, but we're not. This isn't intended to, infringe upon any rights the municipality has to regulate short-term rentals. I guess is how I interpreted that.
Despite the fact that they've defined, that they have their own definition of what a short-term rental is.
Right. The state, there's a state law definition under an entirely separate statutory regime. It's a whole different chapter of the general laws that deals with short-term rentals and regulations, municipal regulation of that.
Okay.
I think that the purpose of the definition, I think anyway, was, and this is me kind of waxing poetic, but I think it was just intended to recognize the distinction, and we're not suggesting that your whatever rights you currently have to regulate short-term rentals is impacted by by AD. I think.
Okay. That's encouraging. Thank you.
Okay.
I've got a question about the overlap between these two articles. So I'm also looking at the regulations for the ADU bylaws, and the state is telling us that we can have a site plan review. It's okay. I'm trying to parse through all the double negatives. We can have a site plan review that is clear and objective, and impose. Yeah, I'll stick with the clear and objective. Now, 2 weeks ago, I knew nothing about site plan reviews, so I'm still a novice. It seems like our new site plan review rules are a lot better than the old ones and are a lot more objective, but it seems like it's a spectrum. I wouldn't say these are 100% objective. I don't know if any site plan rules are either 100% objective. So I don't know what my question is. I guess my question is, do you think the new site plan rules meet the standard of these are clear and objective?
Well, they certainly were very detailed, and I think I had a couple of comments on some of the terms. I think you have to be, so I guess the short answer is yes. I was generally, satisfied that it met legal requirements. That you have to be deliberate when you're dealing with site plan. First of all, you're not alone. You said that it's kind of an elusive concept that judges bemoan all the time. How kind of esoteric site plan review is. It's not really addressed in the Zoning Act in detail. A lot of people have lamented that. I think there's one judge described it as the ghost that haunts land use, which I thought was kind of you hear that repeated a lot. You have to be careful about, there are limited circumstances in which you can deny for as of right uses, but you have to be very careful about that. There's I'm paraphrasing, but there's language in decisions that says something to the effect of, you can't wholesale deny site plan approval for an as of right use unless the problem is so intractable as to permit no resolution or words to that effect. So you're very limited in terms of, so you have to be careful about that. And when it comes to multifamily uses, there are also, if you read the site plan review decisions that I mentioned, there are certain restrictions on site plan review in the multifamily housing context. One thing that jumps to mind is when they caution against, they being the MLU cautions against considering like public impacts on public services, for example, when you're dealing with multifamily uses. That's something that I've seen in a bunch of the decisions. I don't want to get into too many, I guess, of those particulars, but overall, it was generally, I thought generally speaking, it was in good legal form.
Can I ask a follow-up?
Sure.
So this may be sort of a loaded question. The warrant committee voted to recommend that town meeting accept the site plan review. We don't know what town meeting will do. My loaded question is, would you say the old site plan standards were clear and objective? And if they're not, if town meeting decides not to follow our recommendation and upgrade the site plan bylaws, would that mean that a site plan review could not be done on an ADU?
Oh, interesting.
If the old one is not.
You know what? I've been more focused on the new proposed language than the existing. So I don't.
That's probably going deep into the weeds. I don't know if that's going to influence town meeting. So I withdraw my question.
Thank you, Jay. Thank you. Julia.
Thank you. When we were discussing the potential limits around, short-term rentals and periods of time, regardless of what time frame that is, are you aware of any enforcement mechanisms that other towns use or have put into place to, if they find that someone is in violation of that time frame, renting in that time frame?
No,
I don't know if my question clears me.
The short answer, no, it's definitely a clear question, a good question. The short answer is I'm not aware of. I'd be surprised if there had been any enforcement of any ADU terms, given the kind of the infancy of all of this. But I think that the enforcement mechanism would be the same as it is with respect to any zoning bylaw requirement. If you have non-criminal disposition provisions, you could utilize that. You could, proceed under 48 Section 7 for injunctive relief or, to enforce the terms of the zoning bylaw. So if you had, it basically would be enforced like any other zoning bylaw requirement, I think.
So for us non-attorneys, does that mean someone else would have to bring a lawsuit against the offender?
Well, the way zoning enforcement works under the Zoning Act is if someone can complain, and the enforcing authority is the building commissioner. It's different. You can do it different ways, but typically it's the building inspector or the building commissioner. Someone can say, hey, building commissioner, so-and-so is violating the zoning bylaw. I want you to take enforcement action. And the building commissioner can proceed with enforcement. They can bring an action in the Superior Court or the Land Court and seek an order from the court that enjoins the violation that says you, violator, have to stop violating. Or they can refuse to take action. They can make the determination that it's not a violation of the bylaw. And then in that case, the complaining person would have the ability to appeal that to the ZBA. And then ultimately, if they weren't satisfied with the determination, they could appeal that non-enforcement or ultimately the ZBA decision to court. But that's just, typical, that's just the process under 40A, which is the Zoning Act.
So really to sort of get the process rolling, it would be presumably like neighbors reporting on neighbors. Is that accurate to
Well,
say?
some, in some cases, it's the building officials, the building department will become aware of a violation and they'll investigate and pursue their own enforcement. They're the enforcing authority. How they become apprised of a potential violation varies. Sometimes they ascertain it themselves. Sometimes it's brought to their attention through complaints. It depends on the circumstance. I think in this situation, with respect to ADUs, there are, and I don't want to, maybe this is, I don't want to veer afield of the scope of a germane discussion for our purposes, but I think that there probably are some challenges in enforcing these types of requirements because, a lot of times you don't know exactly what the arrangement is and, you'd need to, get into a property or like, sometimes it can be hard to ascertain exactly who's living where or what, there's just certain like logistical challenges to it, but it could theoretically, if someone were, if there were a violation of a provision pertaining to ADUs, and it were clear and you had evidence to demonstrate it, you could pursue enforcement.
Okay, thank you.
Sure.
Anyone else have any questions to the ADU? One.
I would just think a neighbor, if they found out about it, they could raise a complaint, or a tenant could raise a complaint if they have an abusive landlord. There's a lot of ways people can voice their opinion. So I don't think that needs to be one situation where neighbors are complaining about each other. There's so many scenarios where at least could come up. So
Nice. Thank you, Ron.
So I just had something that occurred to me. My only fear with what you said about the HLC striking out the
MLU, the municipal law unit. Yep.
striking out the provision. Thank you, because you're right and I was wrong, but thank you. Striking out that provision or saying, you can't have this provision, but look at our other, decisions for guidance of things that we have upheld. I'm just thinking about that. How would that apply? Because you just mentioned the tenants. And I'm thinking about how would that apply? So if I were an owner of a property and I had an ADU and I leased it out thinking that I'm going to have someone who's going to live here for whatever period of time. I'm just trying to think about like expectations. So a tenant and a landlord enter into an agreement and they both think that it's going to be a certain length. And then now when that's stricken out, that would affect the existing like landlord and tenant. So people's expectations aren't really being met, I guess. You understand what I'm sort of trying to ask? Like those landlords and tenants, you would say, okay, you can only live here you have to live here for a year. Then the tenant says, well, now, as it turns out, you can't do that. I want to get out of this lease. How would that impact the existing lease? Because I would think that they would have to be able to let them get out, or you already entered into a contract, or, like what effect would that have on those people that already entered into that agreement?
Yeah.
I would think that they'd be held to it, but I just feel I don't really know what would happen in that setting with the people that already entered into an agreement where the landlord says, okay, you have to live here for a period of 12 months. That turned out to be unenforceable. And now the tenant's like, well, I signed this contract because I thought it could do that. Now it turned out that that provision wasn't lawful. Where does that leave the tenant?
Yeah. Residential real estate isn't a bailiwick, but I think I would guess
Kind of more like a rhetorical.
Yeah,
than anything.
right.
I'm sorry.
I guess No, I guess whatever the contract says. I mean, a lot of times there might be contract terms that will require that, compliance with all applicable law. Maybe, the change in the law that renders the contract unenforceable might relieve some parties of their legal rights or obligations. But yeah.
Judy, then you. It's going to be Judy, Ron, and Lori. So actually, to build off Liz's, if I can go first, we're talking like contract law, right? And any provisions in the lease that would provide for the situation that you just said, but that would be an action in like housing court, I would assume, correct?
Yeah,
where the tenant would have to bring the landlord in and say, I'm looking to break this.
Mhm.
There was no language in the lease that indicated, if the law is flipped, all applicable laws, I want out. And so that would be probably that would be a contract action, right?
Yeah.
Housing.
I think so. I mean, I said I hadn't devoted much thought or any thought to the question, but that's my off the cuff kind of impromptu. I think it's just a private dispute. We have legal requirements, assuming that would be enforceable. If we have the authority to impose a minimum, duration threshold for a lease term, then if we have that legal authority, and we exercise it, and someone runs afoul of it, with respect to a contract that they enter into, I see that as a private dispute between the landlord and tenant.
Okay, so it's going to go Judy, Ron, then Lori, in that order. Judy?
Okay, my question goes to ADUs. Is there a requirement that, so we'll use the municipality of Milton. Is there a requirement to let the town know that you have an ADU, a vacation rental? Because that is a common use of ADUs, short-term rentals, in regards to like a hotel.
Mhm.
Is that a requirement that you need to let the municipality know you're using that portion of your property as a very short-term rental, 2 nights, 3 nights a week?
Right. Yeah. That's a good question. I think that you need to obtain, authorization to operate a short-term rental property. I think there's like a registration process. I have to confess that as I'm sitting here, I'd have to reorient myself with it. I'm not sure. I don't know all the particulars of that process. I'd have to look at that. It's been a while since I looked at that. Short-term rental issues were. There were a few years ago. I dealt with them more prevalently. I haven't had occasion to really deal with them in a while. So I'd have to look. I'd have to check what the particular requirements are. But I guess my understanding is that you would need to obtain some. I don't know that whether that's through the state or the town or both, but that you need to have some sort of authorization to operate a short-term rental.
In following up on that,
I'd have to check.
but then following further on that line, if there was a requirement to register this particular property that is going to be in use for specifically short-term rentals, 1 night to 30 nights, or whatever, sort of like a hotel. Is there a tax due on your proceeds similar to a hotel tax to, say, San Francisco or New York City or any city? There's a hotel tax that's due to the municipality. Would there be any taxation on the revenue to the town?
Yeah, if memory serves, there is a provision in the short-term rental statute that addresses the maximum amount a municipality can tax, I believe, if memory serves. I'd have to. I'm sorry, apologize. These are excellent questions, but I
think I will ask. I think the person that would know if we currently collect taxes on registered, I'll just call them hotels or short-term vacation rentals. If our town collects them,
Yeah.
because if you go on any of these vacation rental sites, you will see, and you pump in Milton, what's up with Milton? I need to stay there for a week for graduation. How are we losing out on revenue? So I think that question that I just asked would probably go to Nick Milano.
Yeah, I can chat with Nick tomorrow about this question. It's a good one. So
All right, thank you very much, Mr. Miller.
absolutely.
Thank you, Judy. Ron.
To Judy's question, I do believe there's a state tax. I'm not an accountant, and we're not going to talk about. It's not relevant to this law, but I do believe that for short-term rentals, you are supposed to report. You're supposed to get a certification from the state in order to operate. Let's not get into details there because that's outside the scope of this. But I think certain municipalities will have additional taxes because I think certain municipalities on the Cape will require additional city tax. That's not in this law or this warrant. So, but I think there are
I think you're
registrations that you need to do.
No, I think you're right. I just would need to spend 15 minutes refreshing my memory. It's just been a while since I've had any occasion to deal with short-term rental issues. There was a time when, it's funny how that works too. You know, there was a time when I could have readily, I think, just probably gone chapter and verse, and somehow years passed and children were born, and
It's funny.
I'm just struggling to remember it at the moment. Yeah, get through the day, exactly.
I'm looking at the MLU database right now. Looks like 2018. This is pretty awesome. They municipal authority to adopt short-term rental bylaws and right to impose fees for short-term rentals, penalties, limit the number of days that they may be rented,
Yeah.
regulate the class of operators of STRs. So it looks like you can define.
Yeah.
But
My other comment was, Liz, I think the scenario you raised, it'd be a little different because this is a minimum standard. So it can't be less than 12 months. That's the language today. So in that scenario where a tenant and a landlord, hypothetical, it could be that if a landlord says, I'll rent it for 30 days and the requirement is no less than 12 months, I guess the tenant can say, you're not allowed to kick me out after 30 days. This has to go for a year.
I know.
And I guess the tenant could try to say, I need to stay. But that's another hypothetical that's,
Yeah.
I think it'd be a little harder for them to do the opposite, which is to get out of it
Right.
early.
Yeah, it's interesting, Ron. Thank you.
I've been staying in my house for a long time. Same time.
You all set? Lori.
So this is with the municipal law unit now.
The ADU draft. And I, just to, I guess, clarify, is the municipal law unit reviews it formally after it's
Correct.
acted upon at town meeting. So this wouldn't obviate the need for the bylaw to be submitted to the municipal law unit. This is just kind of like an advance review. You know, I think in recognition of the, you know, how new all this stuff is, the MLU actually invited and issued a message to municipal council inviting them to submit draft ADU bylaws for advanced informal review. So where it is right now is with MLU being, you know, vetted informally.
And when do you think we might see that back?
I'm hopeful tomorrow. I kind of laid out the timelines. It's they're probably reviewing a lot of these, and so I don't want to impose on them, but my sense from my discussions with folks there is that they anticipate getting back to us, consistently with the schedule I laid out. And I did mention that the planning board meets tomorrow, so I'm hoping that we get comments for tomorrow.
And something as big as we're saying we want a 12-month lease, and they can only do it for 31 days, that would probably be picked up by if that was an issue, right?
Yeah, I think that's why I expect that any forthcoming
I would
comments
hope
would
so.
address it.
So I guess to solve your question, and we get it back tomorrow, and there's only one ADU application in, and then it has to be built out. I don't think we're gonna have that problem. That's what I was trying to
Thank you.
solve.
Thank you, Rory.
Okay. I had another. I think we resolved this at the with the planning board, but section D, really all of section D, which is design standards. I had asked them about number 1, which had previously said that exterior modifications to a principal dwelling or accessory structure, as well as the construction of a new detached unit shall be, that's what it used to say, shall be architecturally compatible with the principal dwelling, as well as including the use of complementary color palettes, exterior finishes, window types, roof pitch, and other design features. Then the planning board voted to recommend to change that to should be architecturally compatible. So I just wanted your opinion for D. I know you've looked at it like that would meet the requirements because it's limiting. My concern with D1 was that it limits what an ADU can be more than your single family property would be limited. So as an example, when it said shall, I was more concerned about this. I'm not really that concerned about it anymore. But for example, I could put an addition on my house that looks ridiculous compared to the rest of my house with totally different siding and window trims and roof, and nobody could do very much about it. And so with an ADU, to have that requirement that's not present in the single family. So I'm just curious, the language should, and the rest of them are should, I think, like encourage, should. Do you think that would be sufficient to like pass muster with these design standards? Because I'm just thinking of things that we raised before, making sure that we have the answers. I'm not really worried about it anymore myself, but.
Yeah, I think so.
Okay.
I think so. And as I mentioned, one of the, you like to identify and apply hard and fast rules. So I actually appreciate it, I guess, if that's the right word, that the draft regs kind of drew a bright line, like, okay, you can't impose upon an ADU more stringent requirements that you'd impose than you would impose upon or could impose upon a single family. I thought, okay, there's a bright line rule, we can apply that. Then they took that away, so it's kind of squishy, but I think that the removal of that language implies to me that you can. The regulations don't preclude you from imposing, going beyond where you could go with respect to a single family. But again, I think they have to be reasonable and
So this would fall kind of, and I think so too, but for whatever. But from your like legal opinion, that all of this section D would fall within that reasonable. That makes me feel.
ADU, right?
Yeah, the D1 through 7, and most of it says like are encouraged, and there's very little that says shall, except that first one. But
Oh, I have. She keeps declining. Sorry.
Yeah, I mean the word should is sometimes I guess to the extent it allows discretion. If the MLU said anything about that, they might say, we point out that, this language should be applied consistently or uniformly, and, recommend that the board consult counsel and, applying this language or something like that.
Okay.
I would anticipate if they did flag that would be the comment, but.
Okay. Thank you.
Sure.
Any further questions concerning the ADU? Okay. We'll move on. Maybe, I know I kind of gave you the freedom, but I have a list here. Do you want to talk about our 2 citizens petitions, if you could?
Sure.
And maybe start with the appropriation.
Yeah. So one of the questions that I anticipated fielding was the question of whether you can lawfully reduce an appropriation so as to create a deficit. And I contacted Ken Woodland, the chief of the Municipal Finance Bureau with the Division of Local Services, a division of the Department of Revenue. Ken is terrific. He's very accessible and very bright, but he is also very willing to opine and publicly. So I whenever I speak with him, I say, I do ask him for his permission to mention that I spoke with him, and as I did in this case, and he said, yeah, absolutely. So what he said was that, and he said there probably are a couple or a few provisions that would be relevant in this context, but he said that the one that came to his mind in the course of this couple-minute conversation today, and he was speaking extemporaneously because I was posing the question to him on a phone call, was Chapter 44, Section 31, which precludes a municipality from spending beyond an appropriation. He said that basically you can reduce an appropriation by whatever amount remains in the account into which the appropriation was made. So I'm just making up a number. If there's $100,000 left from an appropriation and like 20 of it's encumbered, because he added that nuance that it's basically whatever remains accounting for any encumbrances. So if a check has gone out or if there's a bill received, an invoice, let's just for even number purposes, say you have 100,000 and you have a bill for 20, you have 80,000. So the maximum amount by which you could reduce that appropriation would be, you basically could reduce it down to zero, but no more. So that would be the maximum amount that you could reduce the appropriation, would be the amount that remains from the appropriation, accounting for encumbrances.
Okay. Does everybody understand that?
Julia has her hand.
Julia.
Thank you. So in this particular instance then, based on what Nick was telling the warrant committee on Monday night, there was approximately $283,000 appropriated to this line item. We've already spent close to $75,000. Do we know if there's any other money that has been encumbered so far, or that we would need to account for?
I do not. Nick would know
Okay.
that. I don't know that.
So assuming that there isn't, that brings that amount down to $208,000. So if the citizens who brought this petition forward wanted to move forward with it and have any chance of it, being legal, I guess, they would need to, the article would need to be asking to move no more than $208,000 elsewhere. Is that accurate to say?
Yeah, I think that's accurate. I think you'd need to amend it.
Yeah. Okay. Thank you.
Sure.
Judy and Allison.
Judy, you're first.
Thank you. When Mr. Milano was here, he did say that there is ongoing or non-adjudicated litigation with a 40B project on Canton Avenue. It's still in process. So how would we determine how much of that money we're going to need to continue with the Canton Ave 40B project? To come up with a number that we can reduce this line item to. Because we don't actually have the bill because there's no adjudication in the case yet. And could, in fact, require legal billing.
Yeah. Well, I think it's an inexact science predicting what your necessary legal expenditure might be. But, typically you can formulate a rough budget for a case, which may change depending on the course that the case takes. But the person best equipped to estimate a budget for a particular case is, I think, the attorney handling the case. So I think that case is being handled by special counsel. And ultimately, to get a kind of a ballpark sense of how much more they might need to litigate the case for the rest of the fiscal year, you need basically to ask them. you need to consult the lawyer, which.
So in the terms of you cannot reduce past, so they would have to figure out that the probability of a further reduction via this litigation and go no further down. So say that litigation might come to, as you say, $20,000. So now we take that $208,000, and we would have to say we need to leave $20,000 for when this bill comes in. Would that be accurate?
I think that would be the judgment call. If town meeting wanted to reduce it in such a way as to leave an adequate amount to fund anticipated special legal expenses, litigation-related expenses for the balance of the fiscal year, that would be a judgment call. We don't want to, we technically could reduce it by X. We could reduce it by up to 208, but we know that we're going to need at least 100,000 to litigate this series of cases. So we want to reduce it only by 108. I think what Ken was saying is the authority exists to amend the appropriation down to zero, accounting for encumbrances. So if nothing's been encumbered, if all that's been encumbered is the 70, and apologies if my math is off, but if only 70 has been spent and nothing's been encumbered, then you can reduce it by 208, let's say. But if you want to, as a policy matter, you make the determination that we really don't want to deplete the thing down to zero because we know we're going to need some money in the account, and we don't want to completely defund special counsel services or special litigation services. Then we want to amend it so as to leave enough in there, but the authority exists, according to Ken, to reduce it down to zero. Whether town meeting decides it wants to go that far or reduce it by some different amount or any amount for that matter, that's a town meeting judgment call.
Thank you.
Sure.
Thank you, Judy. Ron and Brian.
When you spoke to Ken, you use the word encumbered. Does that mean, what does he mean by that? Is
What
it
does
like
it
a
mean?
formal adjudicated debt, like a lien?
That's the question. Yeah.
Or
So,
just a planned expense?
yeah. No, this is a great question because I I'm not sure there's necessarily a universal definition of that term. I said, you know, I think he said, and I'm paraphrasing, I don't want to attribute this statement to him verbatim. He might have said something like, you know, it can mean different things, you know, that he was suggesting anyway, that there's no like definitive exclusive definition for the word encumbrance, at least as it pertains to municipal finance. But he cited the example of a check's gone out, you know, so you've cut the check. So I said, oh, okay. Well, again, in the interest of hard, you know, bright line rules, I said, okay, so it's encumbered if the check's been cut. Right. And he said, no, you know, if you've gotten an invoice, that could be encumbered. So if, you know, that may be worth clarifying. It may also be a function of kind of local practice, you know, maybe encumbered means whatever it's meant in Milton for decades. You know what I'm saying? We'd have to confirm that. But Ken said very clearly, it's what remains after you account for encumbrances.
Brian, I skipped over Allison.
And I know just from experience in other places, you know, a lot of times as the fiscal year draws down, as it winds down, lots of municipal clients will ask you for how much are you going to need. You know, at the end of June, this happens often. How much do we need to encumber? Because we need to pay the bills by June 20th, let's say. How much do you need us to encumber for the remainder of the fiscal year? Because if we don't encumber it, we can't spend it. You know, that's so. And I have to confess, I've just basically in those instances formulated an estimate of what I anticipate the remaining expenses will be for that period, and haven't really belabored. You know,
it could be a budgeting.
Yeah,
or it could be the formal you've issued debt obligations.
It could it probably means, you know, it could mean different things, different places. But when I drew that distinction between a check being cut and an invoice being received, he clearly said no. You know, it could apply to an invoice too. You know, so and I guess that's the other thing. The measure wouldn't be from today. It would be from town meeting, the date of town meeting, you know, I think. So whatever hasn't been encumbered as of that date would be the operative amount.
Yeah. Okay. I'm going to go. I thought I was going to hear a mailbox rule come out of your mouth. But you didn't. So I'll go to Allison and then Brian. Brian, I apologize.
I think Judy hit the question I had about any debts, and I think any more time just continues to add to the debts. So yeah, just good.
Thanks, Allison. Brian?
If the town votes to reduce the budget to zero after all encumbrances, and the town is sued a week later, what happens? How do we represent ourselves?
Right. Well, there wouldn't be money available. You know, there are, you could make a supplemental appropriation. You know, but
It's a question.
yeah, I mean, I guess there's, ultimately, you know, the provision of legal services is a cost associated with it. So if there's no money to pay for, to litigate a matter, I guess it would, I don't think there's a one size fits all answer. I mean, if I were like on the eve of trial in a case, I don't know. I've never thought about that. I don't. It'd be an unusual predicament.
I mean, it could put the town at peril by being sued by multiple people because you'd be wide open.
Yeah.
in a way. I would think, right?
Hmm.
Why wouldn't you?
Time to slip and fall. You know what I mean?
Right, there'd be,
Time to do it.
Well,
Kidding.
slip and fall claim probably would be covered by insurance. So you don't have to worry.
Time to slip and fall.
I can take a swing at this. I'm thinking wood chipper.
The one we
Right.
just bought?
Yeah. I'm thinking that the town would come to the warrant committee
Yeah.
and ask to
Oh, yes.
use
Supplemental appropriation.
Ask to use free cash.
No,
Yeah.
not free cash. The reserve fund. Is that what it
Oh,
is?
the reserve fund, excuse
Yeah,
me.
reserve fund.
It's all
That's
the
what would
same.
happen.
Yeah. So they would come, I would assume, just how we've done it, that they would come to us and say, this is how much we need, and what do you say, warrant committee?
And it's not,
Which is a
oh, I'm sorry.
Can I
somebody.
got my hand up.
Peter?
Yeah, I was just gonna say that based on Nick's presentation on Monday, I would assume that in that scenario, it would, they could draw from the reserve fund, assuming that the select board and the warrant committee approved that transfer after, from May 1st or later. Is that,
Yeah.
Attorney Mallow, you're an option as far as you?
Yeah, I think that's right as a practical. Look, there's other.
Yeah.
There would be other pots from which to draw, I guess. Other means to, but you couldn't use the appropriation, so there would be steps required to access any additional funds. But it's not. I have had. I'm familiar with instances over the years where a case, not in Milton, but cases have required supplemental appropriations. A major case where a certain amount was budgeted and there was unanticipated motion practice or some case event that was unexpected that generated a lot of resources and time and fees and required a supplemental appropriation through, from town meeting. That's not, I've seen that happen before, so I think that either accessing reserve funds. I think you're right, though. Nick may have mentioned that as a possibility. So,
Jay, did you have something to say?
I did. I do want to respond to Julia. I think with the reserve fund, it only requires the warrant committee's approval, and I think it can be done any time of the year,
Yes.
not just the last 2 months. Okay. But you reminded, or this last conversation reminded me of something I was wondering about. What can we, I don't know if the correct word is amend, but we're going to make a recommendation to town meeting. And what can the scope of our recommendation be? For example, Mr. Milano seemed to say that it has to be within taking money out of legal and putting it into schools. Like, one of my first thoughts was, instead of putting it into schools, can we put it in the reserve fund? Is that, if the warrant committee decided to do that, would that be within scope to say it's not moving to schools, it's moving to the reserve fund?
yeah.
Mr. Milano seemed to think no.
Yeah, right. I guess the moderator's ultimately the arbiter of scope issues. I guess I'd be remiss, or I'd want to confer with Bob about his view on that. I tend to agree with Nick the way the article was framed, but ultimately that I defer to.
Right. And
I want to confer with Bob on that.
my second question about a reasonable, I don't even want to call it an amendment, a reasonable recommendation that we might offer is, could we offer a lower number? I mean, they've phrased it poorly, as we all know, but could we say, nope, it shouldn't be 255, it should be 208, or it should be 100,000, or it should be $1? Is that within scope of something we could recommend?
I think you can. I think, and I don't think Bob would disagree with this, that you could reduce the amount.
Okay.
I think any reduction would be within scope.
Thank you.
Sure. I mean, Bob may have a different view, but I wouldn't expect that. So.
I think I'd agree with that until I was corrected, obviously.
I had a question from a procedural standpoint. If they were to need a supplemental appropriation from the reserve fund, you said that would go to the warrant committee. the warrant committee would make a recommendation. But that wouldn't go to town meeting. That would be the warrant committee and the select board.
Warrant committee.
The warrant committee. So my concern is, here we have a situation where a town meeting is having a vote. So those people are elected. They're supposed to represent the people that they, in their precinct. They say, we don't want to have this money. Then we, the warrant committee who are appointed, are then saying, never mind, we're going to go, you know what I mean? So I'm just, that tension, I'm not really asking a question, but I just feel like there's a tension there, but you're saying that's allowable as long as you don't encumber. I mean, as long as you don't reduce it down to less than what the encumbrances are. So it's like 0. So it doesn't go below 0.
As long as it doesn't go below 0. Right?
Okay.
That's what Ken said.
Yeah, I'd like to just comment on Liz's thing. I think it is I appreciate the comment, but I think it allows for flexibility.
Oh, I'm not
with the
saying that's
budget.
wrong. that
Oh,
we
no,
do
no,
that.
no. I wasn't inferring that.
Okay.
I'm just kind of commenting on, because I thought it was a good question. It's a good thing to bring up, that it allows that flexibility so we don't have to call a town meeting. So we don't have to kind of do all those steps if we need the money for a wood chipper or something else immediately. So I just think that's probably the thought behind the provision that way. But
I don't have a problem with the provision being that way. It's the opposite. I'm concerned that if this were to be passed at town meeting, what does that then mean? Like if we do need to have litigation because we get sued because I slipped and fell, but something else happened. We're putting the warrant committee in a position where we're having to say, even though people voted for this, I just feel like there's a tension there between, you know what I'm saying? So I think it's good that we have that ability, but I'm worried about this petition the way that it's written, I guess is my point.
Ron?
I guess in theory, I would think that we wouldn't look to have a large appropriation for just any potential cost. It would be for legitimate costs that are being incurred for foreseeable issues. So it could be for potential encumbrances that are coming. And I think that's how we would be prudent about the money, given, in theory, the town meeting would have told us not to put a big sack of potatoes out there for, usage.
Well, yeah, and I think what's gonna happen is, if something happens, if this happens and it gets passed, Nick is not gonna call a warrant committee meeting to move money until the legal budget. He's gonna wait until, there's
Real
a
bills
bill.
come in.
And
Yeah.
he wants more money.
Right.
And then it's an issue because now you have an encumbrance.
But we could meet every month, in theory.
Yeah.
Yeah.
Every month a new bill
Fine.
comes in, we can vote to pay it, I guess.
But there's a bill.
Everyone's satisfied? Not really, but best we can be at this point. I appreciate the questions on citizens petitions. Maybe move on to the next petition.
Sure. Yeah.
This is the planning board, the town instructing the planning board to come up with a reasonable or to implement the MBTA Communities Act zoning plan as presented. So if you could just from your perspective as town council on that article as it's written.
Yeah. So I guess I'm not sure what word you want to attach to it, advisory or non-binding, but it's not, in my view, town meeting can't mandate, that the planning board take specific action in this regard. I mean, the planning board is a public body, is an independent public body, and acts through its collective vote. So, town, I think the petition can operate as something of a proclamation or a recommendation, but ultimately wouldn't, I don't think, have any binding effect on the planning board to mandate that the planning board take any particular action. So that's how I view that.
Okay. Anybody have any questions as to that petition?
Julia's hand is up.
Julia?
Yeah, I have a question that is somewhat related to this petition, but the planning board has made no secret of the fact that they are taking legal advice from a unpaid citizen volunteer. As the town's paid counsel, do you have concerns about, does that put the town at any sort of liability? Or do you have any other concerns related to that in general?
I think it's respectfully. I don't want to sidestep. It's a little outside the scope of this discussion. I mean, I think that in terms of the article itself, purporting to or seeking to direct particular action by the planning board, I don't think that the planning board can be lawfully compelled. The town meeting can't dictate what the planning board does, and I think, I don't want. I don't. I'm not trying to be evasive, or I respect the question, but it's a little afield of the scope of this discussion, I think, respectfully.
I know the select board is going to be making a decision, I think, on the planning board plan upcoming. We heard that at their meeting last night. So they were going to, for those who didn't see, I recommend you go back, maybe take a look at that joint meeting last night. It was very interesting. It was an executive session, but they were planning on voting on the planning board plan as they've provided, or some other avenue the select board was going to pursue, but that did not happen. I think that vote's on Friday. Right?
Yeah, I think that's right.
Jay?
Can I clarify? Are you saying town meeting approving this? Are you saying it would be improper for town meeting to approve this? Or are you just saying it would have no teeth?
The latter, I think.
Okay.
They can't dictate. They can't direct the board, at least in this context, in my opinion.
Thank you. I'm just trying to understand if you meant they can't dictate and therefore they shouldn't pass this, or they can't dictate and therefore it doesn't matter if they pass this.
No.
Okay. Thank you.
Going back, I'm happy to hear that rules are what they are, and as you've interpreted them, so that a group of folks can't change or command one of the units of town government to do something specifically at some point.
Yeah, then I think that's I don't like to speak in absolutes, as you probably gleaned, but because I think there's an exception to every rule generally,
Sure.
which is itself an absolute statement. But I think, no, as a general proposition, like town meeting, there are certain actions that it has to authorize. So you can't take action without authorization of town meeting, but often there's a distinction between that and directing, I think in this context, I don't think that town meeting can require this public body to take any particular action.
So taking that a step further, they could, however, take money away from a elected body, which is the first petition. Is that correct?
Right. I mean, insofar as town meeting controls appropriations and, has to authorize appropriations and could, rescind or amend an appropriation, I guess, in that sense.
Have we seen many of these requests by petition to amend or rescind an appropriation?
An appropriation? Yeah. Anecdotally? I mean, personally, I haven't, but that's not to. I don't know statistically how prevalent it is. Anecdotally, it's not something I've seen a ton of.
Okay, thank you.
Sure.
Anybody else? Okay, one more to go. are lighting bylaws. So the lighting bylaw, the dark sky, and then the light trespass.
Yes. Yeah.
Yes. So I don't know. We've discussed, and actually we're hoping to have a speaker and some additional comments on that.
Mm-hmm.
But you have the opportunity to review the lighting bylaw. Can you just tell the committee the
methodology and
the methodology and its origin and then what you did? That would be very helpful.
And as I mentioned, Jay put together what I thought seemed like very copious and thorough slides that I haven't had occasion yet to fully drill down into. I did notice one item that was an excellent point, and I'll address it in a second. But my methodology basically was to take the draft lighting and dark sky and light trespass bylaws and check, which I understood to be, basically verbatim what was approved in New Marlborough. New Marlborough, as I think I mentioned at the last meeting, was a subject of an MLU decision that I sent to Jay. I don't know if everyone's seen a copy of it. Does a pretty good job of addressing particular provisions of New Marlborough's bylaw that the MLU flagged as potentially problematic. And I just basically tried to address the issues that the MLU flagged. One item that was included in the original version of the New Marlborough bylaw was a line rendering any violation of the bylaw a misdemeanor. And it turns out, if you look at and Jay circulated the town report, the vote of town meeting actually removed that sentence. So when the MLU saw it, presumably they didn't see the version that included that language. I assumed that they had approved it, so I didn't flag it as problematic. If you check the repository and just type in misdemeanor into that keyword search box, it generates a number of decisions in which the MLU has disapproved of similar language. So. And what it said, it's just disapproved of that. It kind of isolated it and disapproved of it. There's two mechanisms to basically enforce bylaw violations. Chapter 40 is 4021, 4021D. And the 4021 process is ultimately technically a criminal proceeding process. 4021D is a non-criminal disposition fining process. But anyway, the terms in bylaws that have purported to render violations of the bylaws misdemeanors have been rejected by the MLU. At least I pulled up a quick decision. I assume there were like 1,000 other decisions that popped up. I assume they all say the same thing. So anyway, basically, generally speaking, the MLU flagged as problematic the kind of the interchangeable use of zoning act parlance in the bylaw, which I try to remove. Like there's references to special permits. The lack of this is my word, but in kind of an intelligible standard that would guide when a light issue constitutes a nuisance. So I tried to add language that would, define what that means, and in a way that that would guide someone making a determination about whether there's a violation, about whether it rises to the level of a nuisance. What does that mean? So I tried to add some terms that kind of define that standard. And then the MLU objected to the way the enforcement terms were laid out. So my thought was to basically incorporate the 4021D process. There was in lieu of a civil penalty provision, and I think that they also had language in New Marlborough that imposed a fine that MLU deemed to exceed the applicable threshold. So that was, my methodology was just to take this language, which I, basically my understanding was the same language that New Marlborough had passed through the MLU, and then address in our language provisions that, with respect to which the MLU had raised concerns. Again, it was those three categories: enforcement, standards to govern, and process, due process. That was the other one. So the MLU said there's really no process to, through which someone could challenge a determination that they were in violation. So we tried to add a process and add some standards that would govern determinations that result from that process.
Can I ask you a question?
Sure.
Based on, so this is a general bylaw
Right.
as opposed to a planning bylaw.
A zoning bylaw.
A zoning bylaw. Excuse, my apologies. So, and correct me, okay, based upon the general versus zoning, what's the difference? You said, they use the language, but is there any, from your perspective, if something's moved forward as a zoning bylaw, what are the are there additional, there's a process, right?
It's governed under 40A Section 5, which is a section of the Zoning Act. It has to be the subject of a planning board hearing. Planning board has an opportunity to draft a report, and depending on the nature of the provision, it could have a different quantum. Typically, traditionally zoning bylaws have required a 2/3 quantum of vote. Been amended in recent years. I won't get into all the minutia because I don't think it's germane for purposes of this discussion, but where the bylaw provision would would create multifamily housing where it wasn't previously allowed either by special permit or as of right. The quantum could be reduced down to a majority, provided this other requirements is going to be in an eligible district. Again, I don't think it's germane, but the Zoning Act, zoning bylaw provisions are subject to the Section 5 process, and also typically have a different quantum of vote. For a general bylaw, it's a majority vote.
So it's the 2/3, and you did mention, and I say this because
It's for a zoning bylaw.
True. And I saw an iteration of this back in 2015 that was brought forward by the planning board, circulated, and really never got traction. But what you said stuck with me. So with the planning board, as we know, there's a public process. So there'd be public hearings.
Right.
Okay, and there was none, and under the general, there are none. There's no requirement, correct?
Right, there's no, a public hearing.
And the report.
Right, no planning board report, correct. Yeah. But this, as the MLU decision reflects, this was passed in New Marlborough with the MLU's approval as a general.
As a general. Okay.
Both of them. Yeah.
Okay. Any dark sky, Lori?
I just had a question about how did you choose New Marlborough? A very rural community in the western part of the state. That seems a little bit different than our bright skies in Milton.
Yeah, I mean, I first learned about it through the municipal law unit. I noted that there's this New Marlborough language was the subject of an MLU decision.
Yeah.
So that's through the MLU. But I mean, I'm not very familiar with New Marlborough.
Yeah.
But yeah, I mean, I think that's certainly a distinction that's something that I think the MLU decision referenced was that it's a rural place.
Right, which seems, I would be looking at Somerville or another community that's surrounding Boston because we're getting the after effects of the lights. So that's just curious.
Any other questions or comments? Mr. Dark Sky? Jay?
If I can ask more about the process of how this came to be. And thank you for what you said just now. You answered some of my questions by the answers you just gave a minute ago, but the process. So you said, I guess my question is, there are other differences between this proposed bylaw and the new Marlborough law. Most obviously questions of what's going to happen with pre-existing lights. Was that additions you made? Were you given that and they said, we've made these changes? I'm confused.
Yeah, no, and I'm happy to address this, Jay. I will say I want to be a little clear. I mean, I want to be a little careful. I don't want to unwittingly waive any privileges. It's a little tricky in this context, but
I was, yeah, that's okay.
But that is language that I added because I wanted to make it. It's not. First of all, it's not a zoning bylaw, so it wouldn't be. The grandfathering protections that the pre-existing non-conforming use protections that would extend under the Zoning Act aren't applicable. And I'm not sure offhand as I'm sitting here what the new Marlborough language was, but I thought that I was trying to be clearer about the circumstances. First of all, requiring that I thought that the language around the terms under which pre-existing lights had to come into compliance was a little ambiguous, at least as I read it. So I was trying to kind of create clear language around that, like a deadline, for example, by which compliance needed to be achieved. I guess the question, if you want to make, I don't think there's anything that would preclude in a general bylaw you from providing the same sort of grandfathering protection. But if you didn't want to and you wanted to make it, if you wanted to require that existing lights come into compliance, I think it's just important to, first of all, identify for clarity the date by which that compliance has to be achieved and what compliance entails. So that was basically the substance of those changes. That was my thinking.
Okay, I've got to say I'm confused. So stepping back a second, a minute ago I thought you said that you thought this language was the same as New Marlborough's, but then you changed it for the MLU. But
Yep.
This is also a change you made. Okay. I guess, I mean, I am, when I read these current bylaws, I'm confused if current lights are grandfathered or not. That's where I stand right now.
Yeah.
So I don't know which wording you added, and I know you don't want to speak for like any select board members. If any select board members added language, I am.
Yeah, and it's hard for me. I'm just, I don't want to, obviously I'm trying to be mindful of any privilege protections that would extend any communications I had, but also,
Thank you.
But also just from a memory standpoint, there were different rounds of, I made changes to address MLU issues, and then, as I recall, opined on other drafts, but I remember trying to be clear about, add clarity to terms relating to pre-existing lights. So if I think I'd have to go back to look at the language, but perhaps, if it could have been clearer. I thought there was a deadline, was a 2-year deadline.
2 years.
Right, yeah. So.
Which seems like an onerous expense for the residents.
I can't be affording that.
Yeah, I wasn't sure if there was intended to be a time to be in compliant now. So what you're saying is if I have a porch light on my house that shines sideways, in 2 years, I got to replace that.
That's what it says.
Or earlier. earlier if you fall into 1, 2, 3.
If your neighbor
Oh,
complains
okay,
about
sure.
you.
But I guess what I'm asking is, if nothing,
Yeah, could be.
is that your understanding that if
Is that?
I've got to replace my
is that
port?
what you intended?
I just wanted to, I think the intention was, and this isn't what this is more the policy behind it.
Yeah, I wasn't going to ask you
I'm
this
just like,
question.
I'm just trying to create,
A legal bylaw.
I'm trying to create certainty and avoid ambiguity and create clear requirements, So I think along those lines, you want to have a deadline. If you're going to require people to come into compliance with a certain time frame, it seems to me the most important thing to do in that regard is to establish a deadline. What that deadline is, it could be 2 years, it could be longer. There could be, mechanisms to, for good cause to extend deadline, but my point is I just want it to be clear what the deadline is and what you have to do within that deadline. But the propriety of any of that, or the as a policy matter, whether those deadlines, what you need to do should be changed or modified, scaled back, or the deadline should be extended. I mean, those are fair questions. Those are policy questions. It's,
Thank you.
I'm just trying to create certainty and clarity.
Yeah, Liz.
A question about the penalties provision. So it says any person or entity who violates this bylaw shall receive a warning for the first violation and shall be liable to the town of Milton in the amount of $50 for the second and in the amount of $100 for the subsequent, et cetera. What is the first violation and the second? But is that my one light is violating again and again? Is that
Every day. Every day it goes on.
Well, there was everyday language before, but is it I have more than one light that's an issue? What does a second violation mean?
Well, is it possible that you have to be handed a violation? So that there has to be somebody there to
But when you park your car illegally, they don't just keep putting tickets on it until you show back up.
Oh, they do. They do
But
now.
not
They
within
do.
one day.
Oh, yes, they do.
No.
My point is
Not
that you may
Milton.
not get a violation every day. Doesn't mean that you
They have to
wouldn't.
come around.
They have to come around to give you a violation every day. And if
But it would be
somebody-
for the same light, Attorney Mel. I could have a violation and then another one for the same light, for the same issue.
I would say yes.
All lights get a violation. So every single light that shines outward gets a violation every day until you fix it. Maybe we're trying to make money for the town. Maybe that was the objective
I
behind
think
it.
that's okay. But
Parking meters.
Parking meters.
Parking meters.
so when I have my light that shines onto my driveway so that I don't trip and kill myself, my children that I'm trying to bring into the house or whatever,
As long as it's not
every
sideways.
time it is sideways.
It has to go down.
I know, but it has to be glowing warm. So anyway, but that would be a second violation. Is that your interpretation too? Is that a second violation would be the next, after I get my first violation, whenever they get around to giving me another one? The same light though.
And the light goes on the next day.
Light goes on the next day.
3 days.
Every time my neighbors complain about me, I don't have any bright lights. Anytime my neighbors complain.
If you keep that light on long enough, we're gonna pay for the new school.
Not for my mom. Don't find any complaints about my lights. I don't have any bright
I'm
lights.
driving down tonight,
Don't do.
making calls to
They're all
the
warm and glowing.
building commissioner. This is so confusing.
Liz, you done?
What would have, I'm sorry,
Lori, go ahead. Brian, after you.
By the way, some of these questions, I mean, when you're reviewing a bylaw, especially one that basically tracks either verbatim or substantially language that the MLU approved, and the question is this in proper legal form? I mean, some of the questions about different scenarios and how enforcement would work in different scenarios, or what different provisions mean when you really drill down. I haven't given a ton of thought to those. And I'm not sure, I'm happy to indulge everyone and kind of give thought off the cuff to some of those questions. But, also, I guess I'd be interested to see how New Marlboro's applied some of these, how it's worked in practice. I will say with enforcement, I've done plenty of enforcement, and as a practical matter, depending on the circumstance, usually it's better when you can secure compliance cooperatively. And there's different approaches to it, and it depends on the circumstances. But I think, for the most part, you're better served to work cooperatively. So.
Liz?
What about the lights that people have that illuminate their trees? Beautiful trees.
No, it's pointing up.
Points up.
Not sideways.
That's a
Violation.
lot of people that are going to be going with that.
Money for the town.
If you can enforce, if you can get the money.
That also might be kind of a
We're gonna have to
safety net,
hire a
because
lot
you
of
have-
people
It's 2 years.
for enforcement.
2 years.
Okay.
Unless
so-
I complain.
Thank you.
Change the bulb.
Thank you. Good.
Lori.
It's not, yeah.
I'm wondering, so is what would have mandated or dictated or driven us to a general bylaw versus a zoning bylaw that would have allowed for public process? I mean, you're sitting here getting pummeled with questions, and I apologize
No,
about things that like we have no idea. This just shows up, and we don't understand what the impetus is behind it. Why did we go general? Why didn't we go zoning? It was supposed to be. It was zoning before. Now it's not. Are we trying to avoid the public process? Are we trying to pass it at 50% versus 2/3? You might not be able to answer that.
I'm not.
so.
I can't really speak to that. I mean, I think that there's a little more flexibility. I think maybe the biggest distinction is, there's I guess a little more flexibility with respect to a general bylaw, and this has been approved as a general bylaw, but I can't really. I guess it's more of a policy question. I don't really.
Okay.
Good. Judy has her hand up.
I think I missed, and this may not go directly to Attorney Mello, but which department in our town is going to be the enforcing agency?
I think the select board, right?
Mm-hmm.
So I think what I'm trying to say is
Mhm.
if there's a report of a light violation, which department handles this? The building department? I don't know.
This says the
So-
select board.
Yeah, the select board.
So they
Well,
will.
any determination of a violation would be made by the select board after a hearing.
And then they would be going forward, they would be handing out these citation notices.
Right, determinations of,
Okay, thank you.
Jay.
I want to ask a little bit more about enforcement, specifically Mass General Law, Chapter 40, Section 21D, which is another thing I'd never heard of till 2 weeks ago, but I'm going to pretend to be an expert. That is I would put in common language, that is a way for towns to enforce bylaws by writing tickets rather than taking someone to court. I believe both of them say, and I'm quoting, fine shall be recovered by indictment or on complaint before the district court or by non-criminal disposition in accordance with MGL 4021D. So to me, that sounds like we can get the fine by taking them to court or writing them a ticket.
Yeah, and that's, oh, I'm sorry.
Okay, so does that mean the select board gets to choose? You're violating, and they get to choose which one that is?
As the enforcing authority, I think so.
Okay, thank you. My next question was, again, I'm a newly minted expert on 21D. It looks like there are a couple hard and fast things that they say you need. One is you need a strict fine. It can't be, and we have that. That's good. And another one is you need to list the enforcing person with a capital E and a capital P, which goes back to what my colleague just asked about. And the only other place we reference 21D in the Milton bylaws is the stormwater complaint, and they list the enforcing person, and there is the, I don't know, DPW, I think. So it's sort of a technicality, but is that a technicality we need to meet in order to meet 21D, list the enforcing person?
Yeah, that's an excellent question, Jay. I'm glad you raised that. I think the identity of the select board as the enforcing authority would suffice, but I can confirm that, and if I feel like there's a need, or the MLU would flag that as something that would need to be either incorporated in an amendment or addressed, then I'll raise that, and it would be something that I think could be adjusted if needed.
Samples that I saw often said, in this example, the enforcing person is the police department, or it's the police department or the building inspector.
Yeah.
Or so would we say police department or select board? And then
No,
I don't know.
No, that's an excellent point. I'm like I said, I'm glad you raised this, because it could be that could be probably identified more explicitly. I think it probably, in my view anyway, I would take the position it's sufficiently covered, but for good measure, it might make sense to, provided town meeting were to adopt it, to amend it, just to explicitly refer to an enforcing official or to the board in that paragraph.
Okay, yeah. And so even more nitpicky, my colleagues will tell you that I like to pick nits. If MGL 21D or whatever, 21D, the intent is that you can dismiss the criminal issue by paying a fine.
Mm-hmm.
For your first offense, you get a warning. How do you pay a fine if you only got a warning?
Mm-hmm.
Is that too nitpicky? Is that a reasonable question?
Oh yeah, of course. No, I think you would. I think probably as I'm sitting here, I guess if I would say that the 4021D process would be available as of the second violation, but
Okay, so sort of the common sense answer. The first one, they get a warning, that's it.
yeah, well, because the paragraph that invokes 21D contemplates that, so I think that's how I would,
Okay.
So, Brian, actually, you're up.
Yeah, I have 3 questions. The first one, do you know if any experts were consulted on these 2 articles at all? Engineers or lighting experts?
no, I don't.
Because you don't know what like the 2700 and the dark sky thing, 2700 kelvins where that came from.
I'm not
What it means.
Kelvins, but
How many kelvins is this?
all I guess when I looked at this, I viewed it through the prism of, okay, this MLU looked at this and flagged these issues. So, I don't know that an engineer was consulted, but I think that tracks similar language or the same language in the New Marlboro provision.
Yeah. Why do you know why this like holiday lights were excluded from these 2 articles?
No.
So you can't technically, theoretically have any holiday lights, Christmas, Halloween. Lights, I would think, or they could violate. They theoretically could violate. Right?
Mhm.
I don't know if that was intentional or. War on Christmas.
Could you imagine shielded holiday lights or bright white?
Yeah.
I mean, like 2700 Kelvin is basically warm lighting.
Maybe we could
And
invent
only,
shielded holiday lights.
yeah,
The
so,
light bulb, you mean?
yeah,
Ones
light
that you
bulb. So it's a
flash
color
against your
temp. So
house.
5,000
Blinky, blinky. I think
are
all the
really
stop
bright
signs
white LED.
that go blinky, blinky everywhere need to be
Cold
removed.
White light.
A check.
Oh,
So this is
That feels like
probably
an emergency
3,500.
safety measure,
Really?
though.
Yeah.
blinky, blinky.
Okay.
Ladies first.
That's what I was wondering, if somebody could come in and show us what 2700 Kelvin.
No, 2700 would be like old, warm, incandescent light bulb.
That's it. Wow,
This is
that's
probably closer to 35, 5,000.
so for
is
outs.
We found our expert.
like bright light.
Please tell me what's 2700. Compare it to something. A candle.
Old incandescent light bulb.
Oh,
When you're back to like,
the screw-in
And-
kind with the
light
filament.
bulb?
Okay.
so bright white LEDs are probably somewhere between 5 and 6,000 Kelvin.
Yeah. These.
And these are probably 35 to 4,000 Kelvin.
What's a full moon? We have to ban that. I'm just kidding.
Down, not in a.
Yeah.
Oh, that's right.
Not,
Down,
not
not up.
sideways. It's
Yeah,
down.
I
Not
guess
the
it's okay.
moon that's glowing. It's
Interesting.
the reflection of the
So
sun.
no experts, no consideration on holiday lights
Yeah,
on this.
I think the experts, I'm not sure what, I think the, when you say no consideration of holiday lights, what do you mean?
Like technically, like you can't have, am I wrong? In this, you can't have Christmas lights or Halloween lights or
If they're above 2,700.
what?
If they're
Yeah,
above
if they're above
2,700.
Yeah,
So no bright holiday lights.
right.
Dim ones.
I guess,
Conservative lighting.
when you think of holiday lighting, it gets a little bit, I think you have to be a little careful in defining, it kind of intersects with like religious, you have to just be a little careful about those types of issues. But as I'm sitting here, I'm not in a great position to answer that exact question.
Yeah, I mean, I don't, like 2,700 kelvins, does that mean two bulbs, is,
No, it's not
54.
it's not lumens is like the brightness.
yeah.
Kelvin is a color temperature, like warm or cold light. And so I can understand where this came from, which is a reaction to when LED bulbs first came out and people started putting them on exterior lighting. It was like daylight.
Yeah.
And very, very
Not
different
like
from when people had incandescent bulbs in. They're like, oh, I find this much more offensive. And some people have genuine visceral reactions to bright lights. And I get it. I don't love it, but I understand it. And New Marlboro, I just looked it up on the map. It's in the sticks. It is-
2,000 people live there, I think.
it's like, makes Great Barrington, which is nearby, look urban.
Great Barrington is urban. I've never heard those two words
I
together.
looked at it on the, I mean, it's
I did
literally.
see it. They did a great job.
Brian, you have any?
Yeah, one more question. So was this particular law, a set of laws, just written for one issue, one problem, do you know, in Milton, one complaint for the entire town? No? Or was it a
That's to my knowledge.
series of issues? You don't know.
No, it's not. I mean,
Well,
it's-
what has started this, do you know? Would you know?
LED bulbs years ago. In all seriousness, I think.
What?
LED bulbs years ago.
Mhm.
But that's why they've adopted different. The bulbs have evolved to LEDs come in all temperature ranges now.
Liz. Actually, Brian, do you have anything?
Yeah, it's.
Sorry.
I mean, that's not. But what started the people? These two articles in Milton. What prompted them? That's what I meant. Like what issue, case?
I just review the language.
All right.
Liz?
I feel like if a neighbor had a problem with a neighbor for like light shining in your house, like bright lights, you could bring a civil action for nuisance, I guess it is, or for trespass of lights. If a neighbor had, is that true? If a neighbor had an issue with their next door neighbor, like shining bright lights in their house or something, they could bring
Nuisance,
a regular
Tort
nuisance
claim.
complaint.
sure.
Okay. So there are like some provisions to protect you if your neighbor is shining bright lights directly in your eyeball. This is more of like trying to have a character of the town to have more like warm, soft, old-timey lighting. But I'm just saying, if we were not to, vote on this in town meeting, were to not vote for it, people would still have some protection for like light trespass.
For light trespass, well, I guess if under typical tort law, if the display of lights is infringed upon your quiet use and enjoyment of your property, like, theoretically, that I think that you might have a claim.
And there's probably, it's probably rare for a reason, I guess, but hard to prove.
Okay.
That's also why nobody ever wants stadium lights allowed, because they're never warm lights.
Mhm.
They're xenon, bright white lights.
Yeah, committee, I just like to mention this too, and like in terms of enforcement, and I understand that the town goes to the court, Quincy District, takes out complaints for bylaw violations, and sometimes I know for health issues, I think it's big. If there's constant problems, I believe the town takes that step, and it's either resolved prior to an arraignment. But you got to remember, someone could catch a case, a criminal case,
Catch a case.
for having like too bright of light bulbs. And they're talking about indictment.
Well, we might not have a legal department.
Well, that's right, but
Yeah, we don't have any.
but the indictment would be by the Attorney General or the county district attorney, and remove the matter to the Superior Court.
Time to install your lights.
I mean, the penalty it could be a fine, or I don't think but you got to remember, someone could get a criminal record if the town proceeds. And I don't know. I just wanted to bring that up to the
Theoretically, and that's language from the MLU's decision in New Marlboro. It actually specifically cited those two mechanisms. I'll say anecdotally, or as a practical matter, the more common approach by many multiples is the non-criminal disposition process, and for whatever that's worth, I think it's not as the criminal process isn't as typical a path in my experience.
And I know there's often great, they take lengths to avoid that. But like the language being in there is just concerning anyway.
Mm-hmm.
So I just wanted, it was more of a comment than anything else. Board Committee, I just want to mention as to this, Attorney Mello's here, Town Council. I'm hoping that we have a guest, a visitor to speak to this in terms of enforcement. And I am expecting comments from the select board by over the weekend at some point that I can share with the committee. I was planning on having a speaker come in the day after President's Day to address enforcement, and obviously, and it would give the select board enough time to kind of draft up some comments that I can share with everybody here. So I just wanted to point that out to everybody, that I could have a little more feedback about this. So if anybody has any more questions just concerning the legality or some of the specific language, and verbiage or whatever used here, here's our chance. So I just want to say there could be more coming on this for our consideration. Like exhausting the issue, I just want to make sure, this is something the select board put forward, and I want to give it all the due diligence we
And
should.
it's obviously not a speak now, forever hold your peace situation. I'm happy to address any follow-up questions.
Sure.
Yeah, you're getting the brunt of it all.
This is an important process, and this is the kind of vetting that serves the town well, I think. So.
I don't see any more hands up. So are we exhausted this issue tonight?
You've probably exhausted our attacks of Attorney Mello.
I would trust. Attorney Mello, thank you very much for coming and putting up with us.
Sorry for your loss.
Well, thank you.
Yeah, and our condolences to your family.
Thank you.
Sincerely. And I know members, if you do have other questions, and Attorney Mello, I think, would be happy to answer them. I'm sure town meeting will have questions. And maybe when I receive more comments from the select board, maybe would be in a position to maybe take a vote on this.
And that's another reason I think this is a helpful process, because it's this is a good testing ground is probably not the right phrase, but this is a good precursor to town meeting. I mean, these are the types of questions. It's good practice, and I like to hear questions that you all have, because you guys do a really thorough job of really studying everything and thinking about hard questions, and if you can make it here, you can make it anywhere, right? So, if I can get by warrant committee, I can make it to town meeting. So I appreciate it, and any follow-up questions, I'm happy to be available. So
Town council, thank you so much.
appreciate it.
Thanks.
See you at town meeting.
Yes.
Okay, great. Okay. So I would like to hold off on the lighting. I'd like to give inspectional services or another the opportunity to come in and answer some more questions, and then comments from the select board member. Are we okay with that? Are we okay coming back maybe Tuesday? Nice kind of pre. We could also use that as a pre-meet for the special town meeting. We can talk about that a little bit and post.
Does anybody else think it's odd that the select board is an enforcement agency?
Yes.
In my experience in town meeting with bylaws, I do.
You think it's odd, or
I think it's odd.
Yeah.
I think they have a lot on their plate.
Normally, wouldn't it be
I would have thought it'd be
the building
town engineer,
Building department or
the
something.
building department, or
some part-time somebody?
and
Because if we're driving home and there's a light that's completely out
You're
of
gonna
compliance.
call
who are you
Richard
gonna
Well.
call? Chair Wells?
Yeah,
I'm sorry.
exactly.
We have a light that is shining brightly on the side.
well, they don't necessarily have to be the reporting agency, but the enforcement agency.
It just,
It just something about it feels weird to me.
I'm back to New Marlboro too,
Yeah.
sorry.
No.
Thank you.
I have a question. Does anybody think this is a good idea? Seriously. I mean, just, Tom, I'm not.
Oh, no,
To be disrespectful. I know that, we're gonna we're gonna beat this thing down. What do you say, if you can make it here, you can make it anywhere, I like that, you should get t-shirt. But this just seems crazy, absolutely crazy. I've said this before, and I'm just repeating it again. And I can't imagine that we're going to recommend this regardless of what information comes our way. I'm certainly not going to vote for it. It just seems crazy to me. I just want to repeat that again.
I appreciate it.
I'd like to respond to the colleague. So I think the dark skies law has a lot more problems and a lot fewer upside. I think the light trespass law has fewer problems and more upside. I think it has more potential to do good. What I don't know, and I probably won't be here when the warrant committee decides this, we've got a couple options. We can, as a warrant committee, say, the light trespass law, it's good enough, and it has some upside. We can say we recommend it. Or we can say we don't recommend it. And if we say we don't recommend it, I hope I'm not getting too far off topic, but for the dark skies law, I think our warrant committee chair can stand up and give a lot of reasons as to why we're recommending no to the town meeting. And I always want to be able to communicate to town meeting why we're recommending something, especially if we're recommending against what another board suggests. So and we don't have to decide this now, I don't know if we can decide it now, but for the light trespass law, will our chair have a similar list of reasons why we're not ready to do it, or why this isn't the right type of law? Or will our chair, or will the warrant committee say, we got two laws at the same time. Law number one was clearly not well thought out. Law number two, we worry because it was the twin sibling of law number one, which is not well thought out, and we need more time. So that's what I'm sort of wondering, and I don't know what decision we'll make.
Jay, I just want to clarify. I was only talking about the dark sky law.
Oh, okay.
That's all.
Okay.
The dark sky law seems kind of just silly, even naming it dark sky here in a metropolitan area with all the lights on. But the trespass, I can see that. If somebody's shining a light and puts a new driveway up, or the example I used was a skating rink on a residential property with stadium lights. You need to be able, and there was no enforcement mechanism. This gentleman could just basically say, nope, keeping them up, keeping them on. And that was the deal. So I'm with you on that. I am pro trespass and anti dark sky.
Liz?
Judy also.
Liz, then Judy,
I guess
and Allison.
for Jay's comment, for the purpose of like completion of discussion, I would say I would like to hear from inspectional services and the select board. Not because it necessarily would change my mind. I will leave my mind open to be changed, but I think because then maybe like whoever's writing the comment, I can just see if I were in town meeting and not having watched all of this, or in town meeting without that. I guess if I were in town meeting and that discussion hadn't taken place, I'd say, well, did anybody check with inspectional services? Or what was the select board thinking? Like, why? So I guess just for educational purposes for other people, I'd be willing to hear.
Absolutely.
But will it change anybody's mind? I don't know. Maybe not.
I'm actually hoping that there's a reason here that I missed.
Yeah, I'd like to hear kind of some of the reasoning as well.
I really would like to know where this came from.
Okay, can we just go to so we get some other people? That's okay. You got Judy, then Allison, and Brian.
Thank you. It seems to me on the dark skies, and Attorney Mello tried to address and make it objective. However, when the enforcement board or department or committee, it's really becoming more subjective. Because who in this case, the article is determining that the select board will be the enforcer. And it could have been any department, I guess. Now, who's going to take training? Is there going to be a training course so that you can be objective and not subjective? I can go to Liz's house and point out a subjective opinion about her driveway lights. But what am I determining whether she's in violation or not? So there would have to be some sort of training and strict guidelines. And I think Brian, I know you're asking the question, and maybe, I don't know, Mr. Chair. I mean, should we talk about the elephant in the room?
Yes.
Yeah, what's the elephant, Judy? Which one?
The elephant in the room is Turner's Pond, because unless you're a movie van pulled up this morning, and you're a new resident of Milton and excited to be here, I think anyone that hasn't been asleep too much pretty much knows that this has been an issue at Turner's Pond. Let's talk about beavers for dark skies, and a select board member on record, on Facebook, which I guess is really a record, worrying about the critters down there, the wildlife, the habitats of the wildlife being disturbed by said lights from one property. And I think, to Brian's point, this is how it started in this town. Although, if we really look at the towns around us, they do have dark sky initiatives. How they came upon introducing in that to their town bylaws is much more research than I would commit myself to. But I think in this town, that's when the impetus to, because there was no law on record to address the lights from one property at Turner's Pond. So, you know, what the heck, I'll be the one to say it. It's pretty well known in town. I'm not going to debate whether the lights are okay, not okay. We should worry about them. We should not worry about them. That's a whole other ballgame. But before us is this article to have our town become one of the many towns in the Commonwealth who have a dark skies bylaws for whatever reason. Maybe they're trying to protect conservation areas. They're trying to distinguish residential neighborhoods from their town centers that have a lot of business and lights that go with that type of property. Whatever their reasons are, we're not an outlier in asking for a dark skies initiative. So I guess to Brian's question, because I was somewhat tracking that, not, obsessively, but I kept my eyes and ears out for information on that down there. And it's a tough thing when certain things can't be enforced, but they're problematic for a large enough group of people. So that's, Brian, that one's for you.
Thank you.
Okay, Allison, Brian, Peter. And then Liz. Let's try to wrap it up.
Mine's gonna be quick, because I think we're beating this to a dead horse on some of these topics, but that was a article created not by the select board, just so we're aware, but it was created by one of the members. So the select board hasn't discussed this. So this is not a fully vetted or communicated article, just so that people are aware. And this was based around the resident at Turner's Pond. And I just think that it's important to note that it did create for an environment for others where we begin to look at this resident, and I felt really bad. I don't think it's anything intentional, but there's safety concerns for him as well. With it being a high access area, I think they put up a sign for that the pond closes at dusk. But so that being important to know, because the goal here is not to create where neighbors go against each other, but to work together. So I think it's important to note that this type of creation of a bylaw could further create divisiveness amongst those that should be working in favor of communication and working. So I think there's more to that. So we can't really approve this based on, we have to do what's like right for the bylaws going forward. So, and if we want to be a town that works together, I think this could be very divisive. So I think that's important to note, but hopefully that gives enough context in that the select board didn't discuss, or this is coming from one person on the select board area. Thanks.
Thanks for that comment, Allison. And Brian, before you go, Allison's correct that I don't think there's been an open formal discussion of this bylaw by the select board. There has been no comment from them on it. That may happen the night of town meeting, which it frequently does, or before. And that's up to the chair of the select board. So Allison is correct. And I thought her comment, I don't know, I'm just going to add to that. It was a good comment. I thought about that a little myself. Brian?
Thanks. I'll try to be quick. Peter, I agree with you completely on the law. And Judy, thank you for bringing up the elephant in the room. And I think that is probably one of the issues, is that they're trying to write a law for maybe one singular item. But I think it's like, I don't know at what point, where I think you could try to pick apart and say, well, we should have a light trespass law, or we should address it. But it doesn't sound like this was well thought out at all. And there's so many holes in it. And at what point do you say, well, just go back to the beginning and, do we rewrite the whole thing for them, or does somebody, that's my thought.
Yeah. And Brian,
There's so many issues.
I can try to answer that and someone can chime in, but, we either recommend town meeting vote, or we say no, and give our reasons why, or we suggest that it be sent back for further review and maybe a little more work. And maybe the select board will work with the planning board this time. I don't know, but I mean, those are really our options.
That's it.
Okay. Peter?
No, I'm good.
Good. Peter, Liz?
So to agree with Allison, I think that, your point, Allison, about not wanting to encourage division in the town is a really good one. I also worry kind of to the point about, I think, Andrew, you're the one anyway, somebody made it about, was it weird that the select board was that you? Yeah, that would be enforcing it. So I thought of another concern. I don't worry about this with this select board, but some future select board maybe. If the select board are elected, and I would rather have a employee, because if you're elected, then I am concerned that, and again, not our current select board, because I think they're all very honorable people, but if you had a select board that was different people, you go after kind of, oh, these people are with me, those people aren't with me. This person's my friend. They voted for me. They donated to me. I would think that it should be an employee of the town who's consistently works here, no matter which way the wind blows in terms of politics. And as Judy said, can inform themselves, have training, and apply it consistently. And then I think that will also help not to, as Allison mentioned, we're trying to avoid, but would help not to sow division. So that's just another thing that I thought is kind of an issue. But your question about the select board enforcing it, I thought, yes, that's true, because why they're so busy. Like, this seems lower tier, but also I do worry about Allison's point. And I also am aware of this whole Turner's Pond situation. And just to add to kind of Allison's point, and I think your point, Peter, like, to have a law kind of driven by one person, I would like to hear from whoever on the select board that you're having come in to sort of talk about the genesis of this and the intent. Because if that's the case, then I would find that problematic.
Can I just add
Sure,
one
please.
quick comment? I find lots of parts of this law problematic, but I do understand some of the rationale. And the example I would give is, two different examples I would give is, if you drive down a gas lantern district, and all of a sudden they swap those out with 6,000 Kelvin bulbs, which is like daylight, you'd be like, this is not pleasant. And the same goes for a long stretch of street. If everybody on but you had these bright white exterior lights, you'd be like, this is not pleasant. It's like daylight. And the flip side would also be driving down Canton Ave towards Blue Hills. And all of a sudden, everybody started turning on everybody on that street decided to turn on really bright lights. You'd be like, the town has lost its character. Now feels like a metropolis. So from that perspective, I sort of get it. I don't know that we necessarily need to regulate it this way, and I definitely don't think having anything that potentially allows for criminal records belongs on there, whether they plan on enforcing it that way or not. I don't see any reason why you should have, why it should be anything other than a civil penalty. So I just want to add the counterpoint. I don't have as visceral reaction to it as some of the other members, but I also want to state for the record that I find many pieces of it problematic.
Thank you.
I agree. I mean, there are certainly, I agree with everything you said. So, and Jay, again, did a great job delineating a number of the issues. But I think it was rushed, even though it took forever to get here. And I think I would refer it back. It needs to start over. And it should probably be a zoning bylaw to have a public process.
Jay.
Yeah, I'm thinking about the light trespass bylaw, because that seems to be the one that we're undecided about, maybe. As far as the select board being the enforcing authority, I'm not concerned with what Liz said, because I sort of thought about this also when the alcohol question came up. Oh, will the select board discriminate in who they give alcohol permission for? Well, the select board already gives one-day liquor licenses. They give permanent liquor licenses. The planning board gives approval and not approval. And somehow, through wise town employees and wise town council, we have avoided discrimination on the decisions that the select board and the planning board and others make so far. So I'm not terribly worried about that aspect of them being the deciding factor. What makes me less happy is I think I know why the select board is the decision-making authority, because that's who it was in New Marlborough, Massachusetts. Would it be better if it was, I don't even know, the building inspector? I don't know what the building inspector does, but I'm just throwing out words. Would it be better if it was a certain town employee? Probably. Is that a change that we can amend between now and town meeting? Maybe, not very well. Is it? So then with the light trespass bylaw, I think it has a few flaws. Question is it worse to implement it, or is it worse not to implement it? And I'm not sure. So you're welcome for that wisdom from me.
No, thank you, Jay. Ron.
I think this discussion is great, but I think we're debating the laws before we have the remaining guests. I would just say we could probably go home and listen to these other people and then talk about this stuff. The same discussion today.
Wise Ron
What a
Cia,
great idea.
striking common sense into the chair of the committee. The purpose of this too is there are people watching, they're drawing from us, and this is why we exist and why we're appointed, not elected. So I appreciate the comments. Are we done with this? We're going to come back one more time, and we can vet this a little more. So right now, it's 20 to 10, We have a meeting scheduled for tomorrow night. We need not have that meeting. We can act on anything we'd like to act on tonight, or we can wait till tomorrow. And maybe short discussion, potentially vote maybe on something, everything, exception of the lighting bylaw. I'd like to give the select board, the opportunity to present us with something. But committee, it's your time.
Which ones are still outstanding?
We have the ADU, the 2 citizens petitions, and the 2 lighting bylaws. Total of 5. It would be a total of 5 votes.
Can we vote on the ADU now?
Well,
We just need a motion.
I'll make a motion to vote on at least the ADU part now.
okay. Liz has a motion to
Great.
vote on the ADU.
We'll talk about the other ones in a minute, but for now.
The ADU bylaw
Right,
as amended
thank you.
by the select board with the Warrant Committee's help.
Now the
I meant planning board, I'm sorry. You know what I'm talking about.
Select.
The planning board and approved by the planning board. Okay, so Karen, this would be our redlined draft that we did the other night.
Is that the same one that's in this, or is it changed?
It's changed from there. I can
Okay.
share it if you need it.
Just let Karen put it up so it's before us,
Yeah.
Change and encourage.
procedures. And we were all, I think most of us were present here when we went through that. There was a very well-attended meeting. Appreciate it.
Was that yesterday?
No,
Or
no.
Monday?
No, it was like
Weeks ago.
a couple
That
weeks
we can
ago.
go Monday.
Remember when
Monday.
Chair Hall was here, and then Cheryl Tagayas
Right.
and Maggie Oldfield were
Maggie
here, and then
3 weeks.
It was Monday.
Were you at the first round of the bean pod?
I was at the first
There we
time.
go. There we go.
well, it was very similar language to what's in the warrant. Just a few like kind of typo-y things were changed. But.
And Ron, yeah.
Only thing with the ADU, so Attorney Mello was still waiting for feedback, but we could still vote on it, subject to the feedback he gets.
Correct.
And we would,
Correct.
at the meeting, I guess, discuss that, I guess.
Agreed.
Correct. And this can, like, if there are issues, I work with the planning board, I'll work with you, we'll work with the town administrator and town meeting to get the correct language in there if there's a major issue.
Did he
Jay?
say he was going to get something tomorrow?
No, I think that was a remark that Lori made to me. Like if they were to find out tomorrow.
Jay, we're beholden, so we have these, the draft regs, and
It is
there's a
tomorrow.
planning board meeting tomorrow.
Yeah, we don't know.
Okay, I thought something was coming from the state, like
Something
model bylaw.
has come from the state. It's been promulgated, we just haven't had the
Oh, we
chance
haven't gotten it.
to like review it, and the planning board hasn't had the opportunity to see it.
So then I don't see why we'd vote tonight as opposed to tomorrow or next week. We're going to be meeting next week.
Somebody could
I
second my
would,
motion.
I
I second it.
Thank you.
I'm good to vote. Because we might not have to revote.
yeah, we always can review. Okay. Can I ask another question? There was, last time this was up, there was discussion about the 12-month. Do we scratch it? Do we not? Where did we end up? No change?
No change, I think.
Yes.
Well, can
Unless someone wants to make a friendly amendment.
You didn't make any changes.
There was no change to that. We were just discussing it and waiting for Mr. Mello to come in, Attorney Mello to come in.
Because we thought the whole 61D was an issue, and he said it. He
Because
doesn't
he
think-
really
said
answer
he
the
didn't
question.
think it was.
He
No,
doesn't.
he said he didn't think it was an issue.
Correct.
What that was a clarifying question that I had asked him, which was Macy brought up the point that it was in violation of she believed that it was not in line with the current regs, which defined short-term rentals as 31
Yeah.
days. The question that I had asked him was, I thought I heard him say that the AG's office was reluctant to take away the rights of the towns to regulate short-term rentals. And so I was basically asking him, is there daylight between towns being able to define something greater than 31 days and what the state says? And I still think I got a waffling answer, which is I'm not sure.
he didn't seem to think so, but I thought that he said that if you vote on it, they'll just kick it back to you and say, you have to fix this.
I thought what he said
One of the
was
things he
Well,
said.
they can eliminate
Yes.
the defective part of the provision
Right.
and return it as a whole.
Yeah,
But-
which is what the planning board told us.
Right.
Right.
You know,
Which is
when they-
what we might find out tomorrow
Right.
when they get it back, because they could have it back tomorrow from the MLU.
Liz.
yes, and I thought that what he was saying was that, as with all of the things in the ADU, that if it was determined that it was unreasonable, so yes, we can still regulate short-term rentals, so things that are 31 days or fewer. So yes, we can definitely not allow the Verbo and the whatever Airbnb. Can we do anything between the 30 days and the 12 months? Somewhere in there, yes. And it would be whatever they determine is reasonable. And we don't know what that would be because they would have to determine. It's kind of what I understood him to be saying.
I agree.
Yeah. The state wants us to have ADUs, but they're still letting us. They're giving us guardrails.
Which was that he had reviewed that provision, thought about it, decided that the language was okay.
Correct.
So that made me feel better about it.
So the motion, I'm sorry.
Okay, we have a motion from Liz.
Macy has her hand up.
Macy.
Thank you. I propose that we wait until next Tuesday to vote because I found some of his answers to be vague. Maybe it's just me. I don't know, but that's my thought. And I don't know if everyone else agrees or someone agrees, but I feel like there's a lot of things to vote on. And I think, at least for myself, I like to be able to process it and incorporate his comments and have a chance to review some of the bylaws before making a decision on them.
We have a motion that's been seconded.
Well, we have Liz's motion on the floor to vote on the amended bylaw as it appears on the screen, approved by the planning board after our dual meeting. So there is a motion on the table.
It's been seconded.
Seconded.
Can I add
So
something
I would
else?
like to raise my hand for an amendment to the motion. I guess would be the proper procedure.
Okay.
That we concur with Macy's.
Okay, guys.
No, that's not an amendment, Judy.
Amendment.
It's not an amendment. Okay.
Not an amendment.
Can I ask a procedural question?
Sure. And then Liz.
If we vote tonight, can we, and we come back and we get different answers on Tuesday, can we re-vote?
Absolutely.
Okay.
Let's go for it then.
And I think we have. I mean, if they're saying this is a no-go, we're not standing up and telling town meeting to vote on it. So I mean, we would take corrective action. Liz.
Be willing to go forward.
So the planning board looked at all of that, decided it was okay. Town council looked at all that and decided it was okay. So I feel better about voting. So I continue on with my motion that Lori so kindly seconded.
Okay. The motion's been seconded. We have a Jay.
I would like to make an amendment. So I'd like to say that in the discussion last week, there were two concerns with the 12-month. There was the is it legal concern, and there was the policy concern. Is this what we want or not? And if we think we're okay with the legal concerns, there's still the question of do we want it or not? So in that vein, I would like to make an amendment that where it says ADU may not be rented for periods less than 12 months at a time. I would like to propose an amendment that 12 be reduced to 6.
Okay, so Jay has an amendment on the floor, a friendly amendment to amend the zoning bylaw as it appears on the screen approved by the planning board. And
Can you just tell me the section? Because then I can.
C7. To change from 12 months to 6.
I personally am not going to say more to this because we discussed it at length the other meeting. I don't know if everybody's there, but
Thank you, Jeff. Okay, once it comes up on the
Take my second, sorry, I'm just
Oh,
gonna
yeah.
save it.
Take your time, Karen. Thank you. Okay, thank you, Karen. It's up on our screen. So this is a friendly amendment to the amended bylaw accepted by the planning board to section C, subsection 7 regarding the 12-month period and reducing a J from 12 to 6.
Correct.
Okay. The motion on the floor. Do I hear a second?
Second.
Julia has seconded the motion. Are we good to call a vote? Any comments?
Can we talk about?
Comment.
Yeah. Thank you. I would like to hear your comment.
Comment, Brian.
Comment?
Comment as to
I
Jay's.
think I'm against it. I think that Milton is, I think it's a great community. I think we should stick with the planning board's recommendation. I think Milton is a series of neighborhoods, it's a community. I know all my neighbors, I bet everybody else in this meeting probably knows them really well. And I think that you would want to have people there, long-term residents. I think you want some continuity. And I think you don't want people maybe moving around like every 6 months, bouncing around. I don't think it's good for like kids that are in school, possibly, that might be there. I don't think it's good for them. I think you want longer-term people if you can. So I agree with the planning board's recommendation on it. If I can say anything else on it. Judy.
Okay, Liz and Judy on the amendment, Jay's friendly amendment.
Well, I mean, my concern is that I also personally think that 6 months is a little bit long if we're trying to allow people to have less than year to year. So, I'm trying to just sort of put my own personal aside and think, okay, the planning board kind of recommended this, but I almost think it's better to have, what is that, the MLU?
Municipal law unit.
Come back and say, this is unreasonable, and then refer us to what is reasonable, because maybe 6 months is unreasonable. Maybe anything more than 1 month is reasonable. Maybe 12 months is reasonable. I think that they might indicate to us sort of what is appropriate.
I would expect them to.
They might say, you can't have even 3 months. You have to have one. I don't know what they'll do, but.
Okay. Thank you, Liz. Anyone else? Peter?
Judy and Macy.
Judy.
Judy next. Peter, Macy.
Just a comment, I think this whole ADU was planned by the state to improve housing options. Clearly, towns want to not turn themselves into the hotel rental business, but the spirit of the law is to create housing options. In that vein, the majority of rental housing options are 1-year leases, or what they call long-term. So I think we should keep that in mind. The spirit and intent of this ADU by the state in 350 towns is to create a housing option. There's plenty of hotels out there. So that's all I have to say.
Thanks, Judy. Peter.
I think I'm with Brian on the 12 months that the planning board put forth. They spent a lot of time and effort putting that together. If it's not correct, it can be changed, it will be changed. And I'm just going along with the document as it was written and approved by us, or edited by us at the last meeting.
Thank you, Peter. Liz? Anyone else?
I wasn't raising my hand or anything.
Yeah.
You just think
No.
I'm going to talk over.
Oh, Macy, I'm sorry.
Maybe she's.
I agree with Judy and Brian. I think the 6 months, it seems, and with no disrespect to Jay, it seems like we're just pulling numbers out of the hat, out of a rabbit's hat. So I think we should stick with the 12 months. I understand the intent behind the 12 months, which is to promote longevity in our neighborhoods and investment in our neighborhoods. And if there's a problem and if it comes back to us, we can revisit the issue. But either, we keep it the way it is or we don't at this point. That's my thought.
Thank you, Macy. Andrew?
Not to create a roadmap for skirting the law, but we did discuss last time that there is no real enforcement mechanism. So I don't think there's any harm in having 12 months in there. And regardless of whether I think 12 is arbitrary or 6 is arbitrary or whatever, I think there's a lot of room for flexibility for renters and rentors. So I'm for leaving it as is, as written.
Thank you, Andrew. Okay, are we maybe ready to take a vote? Kind of have a feeling of where people are going. Okay, so as to Jay's friendly amendment to reduce Section C of the ADU bylaw as the new addition as approved by the planning board, and that would be Section C, subsection 7, reducing from 12 to 6. Karen, could you call the roll?
Sure. Tom?
No.
Steve?
No.
Lori?
No.
Liz?
I'm sorry. I'm so confused.
6 months.
6 months friendly
6
amendment.
months. No, I'm sorry.
Jay?
Yes.
Allison?
No.
Julie? She may have left. Julie?
She's here. No.
The choice?
I'll call her again at the end. Andrew?
No.
Macy?
No.
Julia?
Yes.
Peter?
No.
Brian?
No.
Aman?
Nope.
Ron?
Yes.
Judy?
No,
I'll try just once more. Julie Joyce? She's gone. The motion does not carry.
Okay, so now we're back to the original amendment, the original article as amended by the planning board the other night, Article 11, as written on the screen just a few moments ago. We're very familiar with it, but I don't know if there's a law or it has to be up there, but so we had a motion on the floor to vote, right? Okay.
Time for vote.
Time to vote. Unless anybody has a final comment. Okay. Karen, can you call the roll? As to the article.
Tom?
Yes. No. Excuse me. No.
Wait, what?
What, no. You're like voting the opposite. You're voting the same as you did for the 6 months.
Maybe you want to do that.
Yeah, you can, but
I might be wrong. Are
think,
we voting to approve the ADU article that was amended and approved?
As amended and as approved by the planning board.
Planning board as well as,
Yes.
And you're saying no.
And you say no.
so you're a yes.
I'm a yes. My vote is yes.
You said no.
I'm sorry.
Like 3 times.
That's why I was confused why we were saying no before.
Like that,
I was
it's
very
I'm saying no to the
She
question.
was like,
I'm
no,
sorry.
sorry.
We're gonna
I'm sorry, that was.
get you drown his vote out.
Steve Rhines?
Yes.
Lori?
It's-
Liz?
Yes.
Jay?
Yes.
Allison?
Yes.
Andrew?
Yes.
Macy?
Yes.
Julia?
Yes.
Peter?
Yes.
Ryan,
Yes.
Aman,
Yes.
Ron,
Yes.
Judy.
Yes?
Motion carries.
Good job.
Can I make a motion to return to sender on the dark sky law?
Okay, well, we have the citizens petitions.
Yeah.
And we're not going to get anyone.
We're going to be getting comments from this as to the lighting. We're going to be getting comments I've trusted from the select
The
board.
citizens petition. You still don't think we're going to get anyone, a citizen?
No one has availed themselves, and I've asked all around and all about, with the exception of going to the specific addresses myself personally and knocking on the door, which I think.
I just feel,
And I do have a comment, though, about the school citizens petition that was shared by the chair of the school committee in terms of the appropriation article.
Okay.
I invited them in,
the school committee.
yeah,
Okay.
and they can't come in. They have a lot going on right now, as we all know. It was indicated to me that they were not consulted, okay, when this was drafted. And they have not discussed it at all as a committee and could not render an opinion if they were here tonight. There will be future meetings, probably the week of town meeting, where they may have an opportunity to discuss. But, similar to the select board, I asked, is there anything you'd like me to relay to the committee? And it's just they have no position at this time because they haven't discussed it and they were not consulted when it was drafted. So, Liz.
Similarly, Jay had asked Chair Hall from the planning board whether the planning board had discussed the citizens petition regarding the select board going forward with the action plan. And Meredith said at that time that they had not. Have you talked to her since then to see if I know they haven't because I've watched the meeting, but
No, they
have
haven't.
they discussed
They
that
have-
or are they planning on it?
The planning board, I think, is planning on discussing it. I'm not sure, though. I'm just relaying the information I have concerning the school, and I think it was based upon your inquiry to me, correct?
Yes.
Yep. So, Ron.
For these citizens petitions, what are our options? We can vote to recommend it, vote against it. Is there an option to send it back to who knows who? These 100 people? Is that an option?
No.
You can recommend an amendment. to
To
it,
send it
but-
back would be to say, we don't take a vote today. Go back and re-propose something. So
I think that would be like just voting no, and then they could.
it's like
come back at any
abstaining,
time.
right?
But
I would rather recommend voting against it and.
I'm just
saying
asking
our
options.
ration-
I'm not saying I'm not telling you what I think.
Yeah.
I'm just asking what can we do. So I don't know if that's an option.
That's a good question. I can't answer.
I have an opinion.
Sure.
I mean, it is within the universe of options
Mm-hmm.
to send it to someone, maybe not send it back, but send it to someone. But since both of these are relevant to things that are going to happen before the Maytown meeting, it wouldn't make any sense, I don't think.
And we don't know who to send it to.
Right.
First
So-
petition.
Well, I mean, I think citizens petitions, they can always just bring it back the next town meeting. They could just sign it again, have the 10 signatories who appear in the warrant, and they can just bring it back. What they could, I mean, it's a good point. I was thinking about it. It's like, I mean, we'd send it back to the 10 people and say,
Next time, show up.
yeah,
Yeah.
it's fine. You know, it is what it is, you know? And
I'm sorry.
Judy?
And Allison, but I thought you were.
Okay, Judy, Allison, and then Liz.
I'm looking at almost 10 past 10, and we as a committee, and I'm glad to see that we have so much discussion, and we're not a rubber stamp. But it is 10 past 10. If we're gonna keep voting, how long do we think we're gonna vote? Or should we put whatever we haven't covered over to tomorrow's meeting? Just a thought.
I second that.
I think we can vote on these too. I mean,
I'm going to leave it up to the committee. I have to be here, so and I ask you to come back. And it's I know people we've met so many times. I'm going to leave it up to you. What do you want to do?
Can I ask a next week question, which
Sure.
will inform my tomorrow thoughts?
Sure.
So if we were to vote on these two tomorrow, and next week all we have left is the lighting, and we all kind of feel a certain way about that, would the idea be that we would have how many meetings next week?
I've prepared to post 3 meetings next week.
How many do you really think are going to happen?
I only think we need 1.
Okay.
But out of an abundance of caution, and based upon the advice of previous select warrant committee chairs,
Yeah, that's fine.
I think it'd be good to just have those out there. And if we don't need them, I will cancel them.
Well, just for tomorrow. So we're not saving ourselves a meeting tomorrow by doing it now because we have business to discuss tomorrow. No.
No.
So if we do it now, we can avoid tomorrow and come back next week, possibly one time.
Yeah.
Now, I love to see you all. So I don't mind either way. I'm just trying to understand what
Yeah.
we're talking about.
I
And
like
I will also stay up late. So it's really
like
up
that
to
question.
everybody else.
and I do think
Thank you.
I would
Every now and again.
assume a lot of minds have probably been made from the extensive discussions we've already had on Article 14 and Article 15. So I would hope there'd be a short discussion on these, but people can say whatever they want to say.
Discussion.
I would agree. We've talked about them a lot anyways. I'd rather do what we can tonight and not come back tomorrow if possible.
Yeah.
Right.
Second that.
Is there a motion?
Yeah, I'll make a motion to.
Allison.
Well,
I agree. I mean, I would like to, nothing's gonna change. No information is gonna change your mind. Can we just move forward? I mean, I would like to be with my family tomorrow and other days.
Nice.
I mean, these 3 meetings and this time, I understand what we signed up for, but it kind of seems like sometimes we go around in circles. Let's just get to voting and to the point unless there's any new information that's gonna change anyone's mind. Thank you.
Thank you, Allison.
I repeat the question. Ron, is there a motion?
I would like to make a motion to not recommend proceeding with Article 14, or I can't remember how to.
you want to vote on it?
Recommend the town.
Not
does not.
vote.
Second.
Sorry. We
What
recommending
article
that
is
we
14?
Send
So
it.
we're voting on it, and then he's saying say no, and
So
we're going to say
Is a yes against it?
no.
Correct. The motion is to vote against this, and a
Vote
yes would be
against
to
it.
agree.
Yeah.
No
Which
vote.
article is this?
14.
I know, but
It's
can
the
you say
law
what-
appropriation duty.
Thank you.
Yep.
So my motion is to vote no
No.
To
on Article
recommend the
14.
town vote no.
Yes.
So if you vote yes, you're recommending the town vote no.
Yes,
Correct?
correct.
Yes.
You say that again, please. So a no vote is to not support it. Is that correct?
Incorrect.
Depends on how you want to word it.
No.
Yeah.
So the motion is to vote no on Article 14. So if you agree with voting no on 14, you would say yes on the motion.
So yes means you're against
No.
Article 14.
Yes, it's opposite.
Yeah.
It's opposite.
Yeah.
Dave.
Yes.
Okay, so, okay.
Was there a second?
Well, a little late. It's been a long day, so I apologize. So
It's
a
late.
no vote,
It's late.
a no vote is saying we are not agreeing with it to appropriate the monies. Is that correct?
No, you
That's
have to say
petition.
yes, Steve.
Is that petition 1? I'm sorry, is
14.
Well,
Well, if you don't have the number in front of you, yes, it's petition 1.
okay,
Petition
thank you.
1.
So Ron is proposing that the committee vote to recommend that the town vote no on Article 14, which again means if you think the town should vote no, you're going to vote yes when I call your name. If you don't think the town should vote no, you're going to vote no when I call your name.
Jay.
Correct?
Thank you.
Yeah, I would like to speak to this motion.
Sure.
I'm going to be a minute or two. I apologize.
No, it's fine.
So one thing, our role is to be the wise advisors to town meeting. We shepherd town meeting. And I'll say from the start, I don't want to take $200 and something out of the legal budget. I do not. I very much do not. So to that end, How do we achieve that with town meeting? If we say no, then the motion before town meeting is take $250,000 out of the law budget. Now, I, the other day said, how about if we change this to $1? And I heard a lot of objections that were very philosophical, a lot of objections saying that's setting a bad precedent, that's sending a bad message. I am not a philosophical guy. What I want is for town meeting to not move $200,000. And to that end, I think the most likely way, in my opinion, is for us to recommend moving $1. Why do I think that? I'm dividing town meeting members into 3 groups. One group is Team Yes. They're going to vote to gut this budget. One group is Team No. They're not going to want to take anything out. But then there's who I call the third team, Team Question Mark. And Team Question Mark does not want to go suing the state about MBTA things. But Team Question Mark also doesn't want to empty the budget. So what's going to happen when the motion before the body is take $250,000 out of the law budget? Well, that depends on Team Question Mark. I don't know how they'll go. They don't like voting yes and they don't like voting no. And if they tip the wrong way, we've gutted our law budget. That's what I don't want to see. So I want to see us make a recommendation to take out $1. What if the motion before the body is to move $1? Well, then Team Yes, the people who signed this, they're not going to be happy. They're not happy I'm saying this right now at all. And they're going to amend it to be $200,000. Well, Team No and Team Question Mark are going to vote against that amendment. And it's going to be either taking $1 out will either succeed or fail, but we'll have achieved the goal of not gutting the law budget. And that's what I want. So where does that leave us? It leaves us in a bit of a quandary right now. So far, when it comes to me suggesting crazy things to the warrant committee, I'm at like 0 for 30. But maybe this will be the one time people agree with me. If people do agree with me, then we don't want to do what Ron suggested, and we do want to take this up, and we want an amendment to say, instead of $250,000, $1. I really think that is the best way to guide town meeting to not gut the budget. If people agree with me, agree with me. If you don't, don't. So if Ron's motion goes through, I'll vote no to Ron's motion for that reason.
I have a question.
Sure.
So on Monday, is that Monday?
Tuesday.
Yesterday, yeah.
Yes.
I watched the video, so I feel kind of prepared to talk about it, but whatever other conversation. So, but I watched the video. So on yesterday, we were talking about how much money was going to be spent, not on the MBTA, and we kind of referenced it here, but really, Nick was the one that had more of that specific information than Attorney Mello wouldn't really be the one to ask about that. But Nick Milano, our town administrator, had referenced different amounts of money that were being used for things other than the MBTA. And so to Jay's point, could we limit it to $283,000 or $250,000 minus whatever amount of money that Nick Milano thought that we would need? I don't know that he actually had a number, but something that we would think would be appropriate if people wanted to follow Jay's plan. I don't really like the, I'm not saying this, I'm just putting it out. You're shaking.
Just a tick.
So I don't know that the
He does it to me too, Liz. He does it to me too.
Well, I was going to talk.
Liz,
I don't know that the $1, but if people wanted to go down that road, maybe it could be a different number that would be more likely to cover what Nick was talking about, the other kinds of legal action besides the MBTA. Because to Jay's point, if there are people who are like, yes, I am going to agree with this 100%. And then there are people that are like, nope, absolutely not. But those middle people that say, I don't want to spend the money on this, but I also don't want to hamstring us from all the things that we talked about. That's just a thought. So if we came up with a number based on what Nick had told us, or ask him, but I think he kind of mentioned, what a budget would be minus that, because we had paid Goodwin Proctor like $250,000, but it was a flat fee. So we don't know if there will be ongoing litigation, what that would cost. We know kind of what their one-off like emails, very minimal, he said. So we don't know what that would cost, but if we could calculate what the legal budget might be minus that, maybe it is $250,000, you know?
Steve has his hand up.
Okay, Andrew, Steve, Lori.
I have two quick comments. One question, which is, can't we just recommend no, and don't we write a rationale why we vote no anyway?
Yeah.
So in my mind, what difference does it make whether it's $1 or $0 if we're saying no because of this reason? The other is with regards to encumbrances. What Attorney Mello also mentioned was that it was a fuzzy definition. So whether there's a PO purchase order that's already been issued, or it's what we believe to be a likely future expenditure, the town administrator can define what an encumbrance is, and it could be $283,000.
Right. I'm sorry, go ahead.
Steve had his hand up.
Yeah, Steve.
Oh, thank you. Just trying to take it all in. I don't agree, with respect, I don't agree using $1 as a reference. I think it could be perceived in many ways, right? When you're negotiating, you come back, you respond with $1, and they ask for like 33,000 or whatever. The big concern I have with this is we're in a financial crisis in town, and we're moving money out of an area that we know covers us for risk. It does not seem logical to me to move money out where we need it. It's like saying, we don't have any water for our fire hoses. I don't understand why we would do this, to be honest with you. So I'm sorry. I know it's late, but I don't agree with moving this money over there like that at all.
Lori?
So I just want to make the point that in the last 8 years, we're budgeting at this level and we're spending the money. And it's been 1 year that the MBTA, there was money left and we didn't have to go back and get extra money. So it's not like we don't incur legal expenses every year. So I would just vote no.
Liz, Jay, Peter, Brian.
Yeah, that was my question. So I think you just answered it. But I remembered that Nick had said that this was in line with previous year's budgets, because we didn't know that all was necessarily that was all going to happen. But we didn't have to ask for more money. So that was in line with the previous year. Okay.
Jay.
That was my question.
I'd like to address Andrew, who said, what difference does it make saying no versus saying $1? The difference is the parliamentary procedure at town meeting. If we say no, then the motion before town meeting is take $250,000 out. And I don't know where that's going to go. Apparently 250 is illegal. They're going to have a friendly amendment to get a different number. They're going to try to figure out the number on the floor of town meeting. It will be anarchy. Or if we suggest $1, I don't think any amendments up will change. We'll move it. I guess what I'm saying is we provide guidance to town meeting, and we get to determine what the main motion on the floor is. And that's a lot of power. And we can really use that power. If we say the motion before the body is to move $1, it's going to be hard for them to gut the legal budget. If it's $250,000, I don't know what's going to happen. So it's for parliamentary procedure purposes.
Good point, Jay. I announced, Peter?
Yeah.
Then Brian and Liz.
I think the best bet for no vote is exactly this, because we know that this is not the right number. There cannot be this number of $283,000 because we don't have $283,000. And we'd have to, technically, again, probably not one of the few not lawyers here. 283 is a non-existent number. It doesn't exist right now. It cannot be pulled because there isn't $283,000. So Jay, to your point of conversation among the town meeting, that would have to be the town meeting discussion rather than, I mean, I guess I'd get there the other way. Our recommendation, to Andrew's point, would be that the town has already encumbered a number of dollars from this budget, and so our recommendation would be no. For that reason and the fact that the select board is going to need additional legal reference in a comment. Why couldn't we do that? Recommend no to this for good, what I would consider to be good legal standing, which is this number is non-existent.
Do you want me to answer?
Can I answer you?
The reason is because that'll be written in a comment that they'll pick up as they walk into town meeting, but then the motion before the body will be $250,000. Andrew said, there's not a whole lot of difference between $1 and $0.
I mean, do we know that there is $250,000?
I don't know. There's probably not. It sounds like there's not.
Right.
It'll be so much simpler if we recommend $1. It'll be so. We'll all go home earlier if we recommend $1.
No, but if they
not tonight, but at town meeting night.
But if they don't know how much is unencumbered, then they can pick a number. If they pick $250,000 and it exceeds the actual encumbrance, then it's invalid.
And if that passes town meeting, then what's going to happen?
Then
I'm trying to avoid that.
They can't pull it out.
Get it.
Brian, then Liz, then Ron.
I knew you were first. I just raised my hand and moved them. Go ahead.
Honestly, I don't really understand the logic behind the $1. I know you explained it tonight, a couple nights ago. No offense, I don't understand it. I think it's, and I think the town meeting members aren't going to understand it either. It's going to be confusing to them. I think it's horrible precedent to allow something like this. And on the face of it, if it's $1, $10, $283,000, I think it's really bad precedent to go with something like this. And it's not even a completely well thought out petition. There's so many other issues with it. And so I think we should just flat out vote no. And it would be great to be unanimous instead of confusing the issue, because it's just going to confuse things if you go to $1, I think. That's my 2 cents.
Thank you. Liz.
I do see Jay's point about the parliamentary procedure. I see Steve's point about the $1 sending a certain kind of message.
Mm-hmm.
But I think that you're right. Some of that might be lost on town meeting. I think that because the 250 or 280, this is in line with what previous budgets have been, because we're going to be sitting there for a while this is all debated anyway. Hopefully in the comment, we can try to kind of explain. I think we should just vote, but
Agreed.
on your motion that you had, but you want to make an amendment.
No, I was just going to make an amendment.
Okay,
Not
now,
you, Jay.
okay, we have Ron and then Julia.
Yeah, I think I agree that I think adding options here will confuse the issue. I think it's better to have a very stark option, and it's either you take out 250 and you screw up the budget, and then people can vote for that if they're not fiscally concerned. That's their opinion. Everyone has an opinion of a vote, but I think when you start adding options, it'll just get way too complicated. I think it'll lead for a very complex night. So that's my opinion, and I would ask that we vote on the motion.
Okay. Thank you, Ron. I'd like to end with Julia.
I think that no matter what we do, what will end up happening is, the citizens who organized this petition, many of whom are town meeting members, will have watched this meeting. They will have watched the meeting on Monday. They will come with a revised number. I think it will likely pass. So I, to some degree, don't want to overthink this, because I actually don't think that whatever we do is going to have a huge influence. I feel like if I was a betting person, that is what I would bet on what happens at town meeting.
Well, that says a lot.
Thank you,
I mean,
Julia.
that's pretty, that's a hard statement to hear because then it just means Warrant's not like a body that's being respected, and that says that the town meeting member of who our members are skewed, and that's not an accurate.
I disagree. I think the
Okay,
warrant.
well, that's
skewed.
the difference.
I think the warrant committee is skewed, not the representative members.
Okay, okay, I think,
That's a joke.
let's wrap this up and let's vote on Jay's motion for $1.
Oh,
No.
I mean, what do we-
I
There's
didn't
no
make an
second
Okay.
amendment.
Okay,
I didn't make
stop.
an amendment.
It's getting very late.
I think it's the original motion.
Original motion still on the
No.
table?
And you seconded it.
Yes.
Okay. Yeah. Yeah. Okay.
Okay, and that is a
No vote.
no vote.
So if you want to agree with you, then you say yes.
Yes. And a yes is no to the article as written.
Okay.
Are we clear? Right?
Mm-hmm.
Correct.
Any questions to this?
Okay. You ready? Tom,
Yes.
Steve,
Yes.
Lori,
Yes.
Liz,
Can you come back to me?
Jay,
No.
Allison,
Yes.
Andrew,
Yes.
Macy,
Yes.
Julia,
Yes.
Peter,
Yes.
Brian,
Yes.
Aman,
Yes.
Ron,
Yes.
Judy,
Yes.
Liz.
Yes.
The motion carries.
Okay, we have one more citizens petition. And it's to direct the planning board to adopt the MBTA communities. And actually, the article is to see if the town will vote to instruct the planning board to prepare for a vote, the 2025 annual town meeting, a zoning article to amend chapter 275 of the general bylaws to allow multifamily housing permitted as of right in accordance with section 3A of the zoning act under Massachusetts general laws 40A, and consistent with the Massachusetts Supreme Judicial Court's decision in Commonwealth v. Town of Milton, in compliance with the regulations for multi-family zoning districts.
I move that the warrant committee recommends the citizens petition as written.
A second.
Okay.
I don't
So the-
understand that.
So the vote is to recommend the petition as written.
Oh, so it's to vote yes.
Right.
Okay.
Right.
I was like, wait, okay.
And is this a binary choice, Mr. Chair? Like if this fails, does that mean we're recommending a no? Or is it too late to contemplate that?
No, it's not too late to contemplate it, but
No, I don't think it does mean that. I think
yeah.
it means that then you could have an amendment, I guess. Oh, I would vote yes, and then if that didn't work, you could say, well, I would like to propose something different. I don't know.
You just said they can't force them to do anything.
It is kind of binary.
Like if this fails, are we expecting someone from the warrant committee to recommend a no recommendation? To move for a no
We
recommendation?
haven't done that on the other ones.
No, we haven't. You're right. We certainly did not do that under our previous chair.
But I
That's
think-
why I'm asking.
We agreed unanimously with all of the other ones to do it. So yes, you'd have to say no because otherwise somebody could make an amendment that they didn't. I'm agreeing with your point.
I don't have a point out.
I don't understand the
You
point.
did.
Yeah, I don't understand the point either.
What happens if, so Jay moved yes on this. If that fails, does somebody have to then propose voting no on this? Is it a binary? Like automatically, if we don't pass what Jay recommended, then that's a no? Or does somebody should then have the motion for no?
Anyone else want to speak to it?
Well,
I feel like we should follow the same logic that we did on the first one, just so it's not confusing. And maybe we should say, somebody should make a motion to vote no to go against
Well,
petition
I
2.
made a motion.
I know that.
Yes.
No,
All right.
Nobody
So
seconded
then we're
it.
gonna have to vote.
Oh, yeah.
All right, well,
Okay.
then if it's all no, it fails. Okay. I guess it doesn't matter.
So that goes to my earlier question. Could we take a send it back vote? Right, because it's either yes, no, or send it back. Those are 3 things.
Not on this.
Or
Not gonna
amendments.
send it.
Citizens thing,
No,
I
there's
think.
nobody to send it back
not-
to.
been
No time for them to
But
do
if
anything.
somebody, if we didn't
tell them
say
what to do.
yes,
Right.
somebody else
Right.
could
You can't
propose
tell
an
them.
amendment to it.
Right.
Yeah.
So it's not an automatic no if your thing doesn't pass. Somebody
It's-
else could
it's
say, well,
non-binding.
Okay,
fine,
stop.
yes.
One speaker at a time here.
Didn't Attorney Mello just say that it's not binding?
Yes,
We cannot instruct the planning board to do anything.
yes. An
So
advisory.
I thought you said that you could instruct them, but it's not enforceable.
He was very specific about that. I asked him that.
So
You could pass this, but it would not have a mandatory effect on.
Exactly.
It is
would
not
be an
illegal to pass this at
advisory
town meeting.
opinion. This is what town meeting thinks you
There'll
should
be
do.
instructions.
In-
Can
are
you
not-
force them to follow instructions? No.
okay.
But if we know it's.
Isn't it, my understanding is that our vote is non-binding on the planning board, is that correct?
That's correct.
Yeah.
Correct.
Liz.
Seems like we shouldn't even be voting then.
I wanted
Like
to
it
talk.
doesn't matter.
It doesn't really matter.
It's like
But do-
it's,
do we-
it's bad. It's like not even a real article.
It isn't.
On the procedural question that Jay raised, which I love procedure, so I wanted to get back to that. I think that if Jay moves, yes. If that were to fail, meaning that people said, no, I don't agree that we should vote yes, I don't think that automatically means no, because somebody could then say, well, that didn't work, but maybe we have an amendment. So I think it's fine to go with Jay's thing, but like just keeping that in mind procedurally. I to Lori's point, so it's not binding, but I also think like I like a check and balance. So having us tell the planning board, select board should do something, town meetings, I don't know. I like a check and balance in my life, so. And I mean, I understand what Allison's saying, and I said this before, I kind of view like, there is some, whatever between town meeting and the warrant committee, but I think again, that's a check and balance. So not everybody has to agree with each other, but does that mean that I have to instruct a different department, elected officials, what to do? I mean, Congress doesn't always have to agree with the president, doesn't always have to agree with the judiciary, but they're not supposed to tell each other what to do exactly.
Separation of powers.
Yeah. I don't know.
Ron.
So my comment on this is that I haven't been overly obsessed with all the back and forth in town on the zoning law, but I do understand that the planning board at one of their planning board meetings, they were taking advice from somebody who's a lawyer.
Mm-hmm.
Then if they're taking advice from people who are lawyers who live in this town, I'm sure very talented and educated, then this warrant committee can also have an opinion. In my opinion, is just if the Supreme Court has come down with a requirement for this town, I think this town should follow the requirement. There can be different opinions, and we don't get into law, but that's all it says to me, is there was a decision by the court, and this is for town meeting to inform the planning board to follow that instruction. Now, I think there's opinions that you don't have to follow that instruction, and that would just be a different opinion. So that's why I would suggest that we do vote on this, and it could be a no vote or a yes vote, whatever you guys like.
So,
Everyone's got to vote.
so the Supreme Court said that we have, the governor has the right, or the AG has the right to enforce laws, zoning laws, but they didn't follow the proper procedure. So it got kicked back because they didn't follow HLC didn't follow the proper procedure. So they can't enforce it right now because they didn't follow the procedure with the town of Milton. So technically, we are following, they are following the courts because they saying, no, we shouldn't be doing it. That's what the issue is. I mean, it was like a split decision, but they are following it because it's not. There's technically, according to the Supreme Court.
So if they're following the direction by the court, then that's fine. Then we should say yes, follow the decision by the court. If the court said Milton doesn't have to do this, then do whatever the court says.
This is sort of the exact opposite of that, though, isn't it?
It's
I mean,
following the
it doesn't say-
MBTA.
No, this is on the MBTA.
Yeah, it says follow 3A.
So
With the emergency regs that haven't been promulgated as per the SJC. And I don't think zoning is an emergency. Is it?
Yeah.
Jay?
I mean, if we cut through all the paragraphs, what this says is town meeting wants the planning board to give a so-called 25% plan by May. That's whether you think that's a good idea or a bad idea, that's what town meeting is saying, please give us this plan. It does seem reasonable for the planning board to provide such a plan to the town meeting. They've done a lot of the work. They told us one would be ready last May. It's not an unreasonable request for, if the majority of town meeting wants to ask for the planning board to give a so-called 25% plan, I think that's not an unreasonable request.
This is saying specifically to not follow the Supreme Court decision because it's saying follow the emergency orders that's being challenged in court right now, and which seem to bypass the whole MBTA thing. They're trying to jump it, which is what they tried to do the entire time. So it's actually, this is like not abiding by what the Supreme Court is saying to do, if you read it. And it sounds like it's just, I don't agree. I think that they shouldn't do it. I think they should follow the court, which is saying they should follow the law. And they didn't do that. So go back and follow the law. I want to
Liz.
comment on it.
Just to, I know this is going to be a thing that's talked about at town meeting, so just to shortcut that a little bit. Again, I maintain my separation of powers sort of thought, but I don't know that everybody would agree with that interpretation of the Supreme Court decision. I mean, I think that it is a split decision. It was determined that the UHLC didn't promulgate the regulations properly. That's true. There is the emergency compliance regulation. So to your point, whether or not those are going to ultimately be determined to be valid, and people could have differences of opinion about whether we should be having a zoning article based on those emergency regulations. But technically the emergency regulations, I don't know that they're invalid until that's determined. So I'm just saying that I don't know that if the planning board were to prepare a zoning article pursuant to chapter 275 of the that would violate the SJC's order. That's the part that I'm picking. I think that they could do that consistently with that decision. Now, whether or not people want to, that's up to people. But the emergency regulations do exist. And I think that it's saying, follow those regulations. And whether or not those regulations were proper because it is or it isn't an emergency, I mean, we could have differences of opinion about that. I still maintain my, yes, in this instance, maybe some people would agree, is that the precedent that we want to set where one side tells the other department what to do, these elected officials tell those elected officials, I don't know. I think it's okay to have, and maybe I like it, maybe I don't like it, but I think it's okay to have the executive branch disagree with the legislative branch. So the select board disagree, the select board disagree with town meeting, or the planning board disagree with town meeting, and vice versa. And the warrant committee can agree with one or the other of them, but I don't know that it's proper for one side to tell the other branch what to do.
Peter.
Didn't I hear from the town council that exactly that one body couldn't tell the other body.
I know that happened.
No,
Yes.
we could tell them, they just don't have to do
Can't
it.
force it.
Well, I
You can't
don't.
enforce it, but if it's unenforceable, so.
So this happens all the time. The president could tell the Senate he wants something to happen.
They do.
They don't have to do it, but he can say, I want to see this happen. And that's just politics, right? That's just how the government runs. Right? The
Sends-
president can't say, you must do this or you're all going to be put in jail.
But we did the
Can
same
and-
thing with we did the same thing with the ADUs. We voted on it even though it was 12 months not enforceable. There's no
Well,
enforcement
We
mechanism.
don't know what that is. It could be. I mean,
No, regardless
it's not
of,
what the law is, but
but regardless of what they set as the date, there's no enforcement mechanism built into it.
But the president can also have emergency orders, which he's doing, and those can be overturned by the Supreme Court. It can be overturned by courts, and that you don't have to do them. That's the same thing, and that's kind of similar, same thing that's happened here in the state. The governor didn't like the outcome, so she came out with emergency orders that now have to get re-litigated, you know? It's the same thing.
Should we vote?
Okay, so just so everyone knows, what's your vote for? Is it a yes? And what does yes mean?
Okay.
Jay?
Yes means that we, the warrant committee, recommend that we do what the citizen petition said, which is, as I would paraphrase it, ask the planning board to bring a so-called 25% plan to the Maytown meeting.
Okay, and a no vote would be?
So a yes vote. Did you get a second?
You did.
Yeah, Ron second.
The yes
So-
vote supports the citizen's petition.
The yes vote means force them to do the 25%.
Nobody's forcing anyone.
Well,
but
we intend to
that
force
side.
them.
Strongly suggest.
Okay,
I
got it.
guess.
But that's,
Peter, what do you need to say?
I just don't understand why we're doing something. Is it that's unenforceable? That just, I don't know. I mean, why is this even, why we, there's a reason they wrote this. And again, I guess, for the fact that they wrote it, good. But the fact that it's unenforceable, should we just basically state that it's unenforceable? I
Well, that would be in
what
the,
difference-
that would be in the comment.
Right, so what difference,
You have to vote on it, no matter.
we have to vote on
we
it
have
no
to.
matter what. So it doesn't make sense to me to vote something that just isn't something.
Yeah,
And one can abstain if they wish.
yeah. I would say, two things. I'm not sure which one you're talking about, but the warrant committee has to give an opinion on every single thing in the article.
Yeah.
We don't have the choice of saying no opinion. And why would town meeting do it? If you're asking that, town meeting would do it to express their opinion. That's the only reason.
First I've seen in 15 years, but, okay, so we have yes. A yes vote is to support the citizens petition and instruct the planning board to come into compliance with the emergency provisions in the Commonwealth v. Town of Milton.
To recommend that the town meeting votes to do so.
Yes. The no vote would be, we're not accepting the citizens petition. And we're recommending that town meeting vote no on this. Okay. We're clear? I think I'm clear. Okay. Karen, could you call the roll?
Tom?
No.
Steve?
No.
You
Steve?
muted? Mm-mm.
I'll come back at the end.
Steve
Lori?
said no.
No.
I said no. Sorry.
All right, Steve is a no?
That is correct. Steve is a no.
Okay. Liz?
I abstain.
Jay?
Yes.
Allison?
No.
Andrew?
No.
Macy?
No.
Julia?
Yes.
Peter?
No.
Brian?
No.
Aman?
Abstain.
Ron?
Yes.
Judy?
No.
Motion does not carry. 392.
Can I make a motion to vote on the dark sky law with the return to sender?
Second.
I want to hear from the.
I told the select board,
He moved though.
that I know, and I'm looking at Andrew, out of respect to the select board member, I don't want to drag these out. I'm not looking to do that, but I kind of like to give that person the opportunity to give some feedback.
I'd like to.
And then the gentleman from potentially inspectional services coming in. And I understand this is maybe a little bit of operation overkill on this one, but like I said, it's out of my deference to a select board member. And that's why I'm asking the committees to give me that favor as the chair, if you would.
Okay. As long as you believe they can fix, there are a lot of
I don't
material defects.
No, I understand that, and I can't represent that. Like I think some other members said that this is going to change anybody's position, but it's just an opportunity for the person who's the proponent on the select board of this just to let their feelings, or their thought process and analysis be heard. And that's really all it is. And we can incorporate that into the comment if necessary. So
on Tuesday? I better withdraw my motion then.
Okay.
Was that withdrawn?
Okay. Thank you, Andrew, very much. I appreciate
So
that.
you will sit here alone on tomorrow.
No, we're going to cancel the meeting. I think.
Oh, you are.
You said you'd be here.
You
We all heard him say that.
I know.
I
I was.
think he
That's why I
meant
said
tonight.
you're going to be
Yeah,
here
like-
alone tomorrow.
There's spirit. I get a lot of spirit. Okay, I really appreciate it, everyone. Okay, so we have our votes. Keep an eye on your email. If I get any materials, I forward them to you. We have I don't know as of yet, but by tomorrow will be a posted meeting for Tuesday, 7:00, lighting bylaw. We can make it really quick. I'll be reading the information. If the speaker can come in, we will discuss enforcement and complaints with that person potentially and be able to vote. Liz,
If we are unable to do that, which days do you have planned for the rest of the week?
I have Tuesday, Wednesday, Thursday.
Nice.
I do not trust that we would need those days.
It's okay.
But
Just
if
in
if
case.
something happens, I would like to take a day off, maybe address something on Thursday. If it's far more complex, we'll have to come in on Wednesday. If we need the planning board to come in,
Okay.
which I hope we don't have to, but we don't know.
I believe Jay is unavailable next week.
Correct.
I'm also traveling.
Okay.
But I'll try and call him. I assume we'll still have a quorum.
Yeah, if yeah, that's another thing too.
Because it's school vacation.
It's school vacation week. Can I get a general sense? Will people be around? Will I have a quorum there on Tuesday? I'll be here.
Tuesday.
I'll be here.
Now
Tuesday.
I'll be here.
I'll be here all next week.
Okay. Okay, so we'll have a
Motion.
quorum. Anybody is not going to be here, you want to send me an email, anything you'd like me to mention, please do that. And I will mention any comments you may have.
I make a motion to adjourn.
Seconded?
Yes.
Aye.
All in favor?
Yes.
Aye.
Aye.
Can you
Thank you.